dispose of
5-7 ବର୍ଷ ଅଛି urgency କଣ ଦିଅ
kindly
ଦିଅ
अब ଏଇଟା fresh
ନା ନା ଗୋଟେ ନା ମୁଁ ଦିଟା ନିଏନି ତ ସରିଲା
ଠିକ ଅଛି
It is second appeal, my lord. Of 23, I have tried listing of the matter. It has not been listed.
ଦିଅନ୍ତୁ
Now, my lord, they have
Sir, ଦିଅନ୍ତୁ
student attached.
ସରିଲା any other
Item 9.
no any other out of
2019.
yeah
Second appeal of 2019.
दियो
second appeal of 2023 the execution proceeding is
दियो
first
ठीक है निकालो
Item 9.
Item number
I'm not
20.
feeling well, madam.
item 9 माने
Petition.
who list
Supplementary list. Action. So I had mentioned
this is 2012 Mr. Bera
throat infection.
you have come to the court
Taken medicine. For that reason, I am
अच्छा मेडिसिन लेके जदी कोर्ट को आसीते आ करिवे कोन
sorted how any date you not see.
Let this matter next week as spread for by learner counsel for the petitioner.
Item number 27.
Interim order to continue. It is made clear that no further adjournment shall be granted.
Second appeal, my lord. Let it come on Friday.
No, let me see how I can adjust to my board that has to be seen.
Well, that is the attachment order, my lord.
Let us see,
Property, my lord.
let us see. Yes,
Item number 27 supplemental list.
27. Yes.
Next week I am for the petition. ଯାଇଥିଲେ conciliation fail ହେଇଛି ତଥାପି ଗୋଟେ attempt ନଉଛୁ ଇଏ ପାଇଁ
List this matter next week as spread for. Yes.
supplementary list item number 1
May I please, your lords? In this case, the petitioner is the husband of the opposite party, madam,
Yes.
and seeking transfer from Jajpur to Cuttack, madam, George family court.
Why?
It's because, your lordship, after divorce, the opposite party has filed under section 125 chair petition before the Leonard George family court, Jajpur, madam. And the CP case also Cuttack family judge, madam. That is page number 24, madam. The TRPC number 255 of 2022, which has been,
This has already been disposed of.
that is disposed of. For that reason, madam, this case may be transferred.
No, Mr. Pottak. No, I'll permit you to appear through virtual mode.
Madam, appear at least.
No.
After
This is a prayer for transfer.
madam, one submission is as because, your lordship, the petitioner and opposite party both are working at Hyderabad, madam, and the house is Denkana, opposite party of Jajpur, madam. So both they are
Sri Honorable Patnaik, learned counsel for the petitioner, submits that both the petitioner as well as the opposite party are presently working at Hyderabad. Further, both belong to Denkana.
no, madam. Opposite party is Jajpur, petitioner is
Issue notice to the opposite party by special messenger. This is a criminal matter, by speed post. Very short returnable date. The requisites be filed by tomorrow peremptorily. Place this matter on 3rd September. Bas. Adjournment.
oblige, madam.
item number 2
Madam, only adjournment, no pen direction.
Quite.
Oblige, your lordship.
Two.
May please, your lordship. Last occasion it was listed and my lords are directed because the other said for the husband they have entered appearance through caveat and I have solved it through.
Who's appearing?
What's
Mr. Om Swarup advocate.
AM.
Om Swarup.
Okay, Om Swarup.
He is not there. Let it come tomorrow. I will grant another opportunity. I'll note his absence today. And tomorrow if he doesn't appear, I'll dispose of. All right.
Like,
One opportunity should be granted. Sri Satyavrata Mahathi, learned counsel for the petitioner is present. None appears for the opposite party, who had already who had entered appearance through caveat. Let's this matter tomorrow.
copy solved.
item number 3
The deserted wife
Yes.
and the daughter filed for maintenance in Bhubaneswar before the family at Cuttack, the family court Cuttack. Soon thereafter, they have been served with a notice from the family court at Bhubaneswar for guardianship of the child. Admittedly, the father resides at Tripura. There is no reason why he should file at Bhubaneswar when he knows that the other proceeding is going on in Cuttack.
Which proceeding is going on at Cuttack?
Cuttack maintenance at the instance of the wife and the daughter. That is at Annexure 2. Page 31.
Normally, I don't allow between Cuttack and Bhubaneswar. I don't allow.
But there
But,
are here are two proceedings. One is going on in Cuttack, the other, there is no reason why two
All right,
proceedings.
take notice. Issue notice to the opposite party by speed post. Fixing a short returnable date, requisites be filed by tomorrow peremptorily. Let's this matter.
September.
না, এটা ত্রিপুরা আছে তাও টিকে করো।
17th September.
Yes.
Let the proceeding before the Bhubaneswar court be stayed, because otherwise I'll have to, the child is studying in school.
All right, further proceedings in CP case number so and so pending before so and such court shall remain stayed till the next date.
Obliged.
Item number 4.
Format legal. Opposite party husband filed a CP case, my lord. Section 9 before the family judge, Baleswar, my lord. And the petitioner is staying.
Take notice.
Yes, ma'am.
Notice stay.
Thank you.
Item number 5.
Pass out.
Item number 6.
It's already completed my side of the argument. That matter where on the remand order, the commissioner was deputed to identify. Yes, that my learned senior has also.
That house ABCD, I remember.
My lord. APG.
Yes.
In this case, the learned friend had filed a petition for bringing the 5 sale deeds on record as additional evidence.
That was rejected.
That has been rejected. Well, then now,
The only thing is that the correctness of the commissioners,
my lord, the correctness of the
I had prima facie, but without taking sides.
Yes.
Don't think it otherwise.
My lord,
I found that probably it does not answer the query because it doesn't say anything about the plot. It says only about the dimensions of the house A, B, C, D.
my lord.
You wanted to,
My lord,
you said that you will convince me about that
My lord.
the exhibit X, I believe.
Yes,
Let
exhibit
us see
X.
that. I think that is the entire point.
Yes, only
Yes.
because the other things which my learned friend argued that has been answered in the previous RSA, it has attained its finality. All others. Only this report. I'll submit on the report from the first page, my lord.
Yes.
On dated the second paragraph. On dated so and so, I reached the spot at 11 a.m. situated on Mauja so and so. I found Dhirendra Patnaik and the apparent number 1, one's husband, and Krishna Chandra Padi, the respondent number 1, were present at the spot. Dhirendra Patnaik and Krishna Singh Padi were signed the spot notice. After
Service of the notice.
service of the notice, I proceed to measure the suit plot in their presence. Now, before commencement of the work execution, I have thoroughly gone through the writ and so and so. The next paragraph, the above plots were situated in Mauja so and so district Ganjam. It is seen that the suit house is bounded by so and so. Now, the suit house cannot be bounded by a road and the drain. And two plots and two plots, I mean, 2 persons' names have been indicated in the other 2 sides, north and south. So, therefore, that shows that the plot is measured. And thereafter, again in the next paragraph where my learned friend was placing, after verification of the settlement map and spot, I fixed the starting point at X with reference to the settlement map, embodied southeast side of the roadside plot. Again here, roadside plot so and so. to confirm its existence, I took some test measurements from the different sides and point and correct is correct in its place. Similarly, point Y is fixed by me as the reference to the settlement map embodied southeast side roadside plot again. To confirm its existence, I took some test measurements from different sides and found the points to be correct. Now, similarly, the point Z is fixed from the reference and again here in the north side plot number so and so. It confirmed its existence. I took some test measurements from different sides and point of measurement. Similarly, K is done from the roadside again here. Now the map, as per the map, the existence of the point X, Y and so links are given. Again here the definition, the links are given of the different points. Basing on the facts of these and circumstances, I measure the suit house. He comes to the suit house, which was identified by the parties. It is seen that the map ABCD is the suit house, that is A to B is so and so, covered under 60 area of 61 decimals plots in plot number so and so. So here he has mentioned the plot numbers, which is where the suit house is. Again, he says that is the suit house. That is the suit plot.
Yes.
There is nothing left apart from that.
This was allowed by this, the commissioner was deputed by the appellate court, first appellate court.
First appellate.
All right. Let us
As per direction of this
let
honor.
us see the order sheet. By which order? By which order was it allowed, and where is the writ? I would like to see the writ.
It was because it was ordered by the dishonorable
Dishonorable
court in the last RSA, the earlier RSA.
All right. So,
That is
a writ must have been issued.
before the lower appellate court, only this order of the
Lower appellate court order, as per this order, directed
no
the.
fresh read or questionnaire, it's nothing.
A questionnaire is in Habani because court given, but there has to be a writ.
No, this is,
It was hereby directed to, commanded to measure such and such. What a language in a
Said I did be
The
by the
commission-
lower appellate court's order. Matter otherwise,
So by which order was that allowed?
yes, RSA number.
this RSA number 91.
RSA number,
Oh,
so I will see.
appellate court.
In the first appellate court, which is that order?
That
order sheet
Exhibit extra देखुना थी सीधे तो ऊपर लिखा ही तो by order
No,
also
ସେଥିରେ କିଛି ଲେଖା
open ଲେଖା ହେଇନି.
लिखा ही नहीं.
No, this is the only the commissioner's report.
Okay. The commission report is normal.
ଲେଖିନାହାନ୍ତି ଖାଲି
Only he has mentioned that before the commencement of the work,
ନାଇଁ
along with the writ
please
writ of
very
commission.
first line reads the above noted writ was received by me
Yes.
on 34/2008
34?
30/4/2018
ତା ପୂର୍ବରୁ ହେଇଥିବ କଣ?
ତା ପୂର୍ବରୁ ଗୋଟେ କଣ ହେଇଥିବ
Because then we'll have to go through the order passed by this court in the earlier RSA.
RSA
Yes.
earlier also I had RSA number 91 of 2014
No, you have placed only the operating portion.
ଆଜ୍ଞା
That
34 ରେ ଯାଇଛି ତ writ ଟା?
yes,
30/4/18 ସେ ରିସିଭ୍ କରିଛନ୍ତି The earlier judgment was on 8th March, if I am correct. 8th March 2018.
Yes. Equally, in view of judgment passed by the Honorable High Court of Orissa in RSA number, 24 order tha. Office to appoint a survey to Sri Ajit Kumar Mahapatra, who shall make an inquiry on the suit scheduled properties under Order 26/9. To make an inquiry on the suit scheduled properties, he doesn't clarify what is to be measured or what is to be examined. So we'll have to go to the RSA order. For a correct understanding of the matter.
yes.
Yes,
Where is that RSA? RSA order?
91 of 2000, that is
I think on record.
page.
ଥିଲା ଗୋଟେ copy.
Recorded.
Was it there?
Yes. The other day he was placing in record order available there.
Please find out where is that.
I have a certified copy.
Please, that will help. You have a copy, if you have a copy, you can,
Yes, I got a copy.
let us see where that, the identity of the suit land is the crux of the issue.
Because of the fact that more area, as your lordship may remember, more area was recorded than the actual purchase. And that has been, my learned senior,
that is-
I will also point out that portion of the statement by the PWs who have admitted that. I will also get-
Those things has been decided by this honorable.
No, that was the crux.
That was only point is the suit plot. If that is the suit plot, which has been identified with the commissioner, then I will show that that plot is mine.
You must, please point it out.
Well,
Point it out.
then here I have a copy.
Paragraph 23 of course.
Paragraph 23.
That is the last paragraph.
No, last para doesn't explain anything. Last para doesn't explain anything.
Then-
Where, yes,
Paragraph 21.
22 actually.
21, okay, 21.
21, 20.
21 में conclusion है order 26 rule 9 apply application ला दरकार.
No, but what is the dispute? Why order 26 rule 9 is necessary? What is the dispute? What is the dispute related?
It is apparent that because of the identity of the plots.
Identity of the plots.
Because identity of the house was never in question.
No, that's what I say
And
that it is in the plot.
Lordship knows how
So now what has been argued before me is that the surveying commissioner's report is adequate to insofar as identity of the plot is concerned.
Yes.
And I think on that ground we can close it.
Yes.
What further argument is required to be made?
nothing.
Only the interpretation of the survey knowing commissioner's report.
Yes.
You have raised a point and validly so that they never objected.
They never objected and that they have admitted.
But
In
will it preclude them from challenging the finding of the first
No,
appellate?
finding of the appellate court can, but when they admit the commissioner's report and the first appellate court finds that that is the suit plot and observes that plot is mine. So therefore, where is the question of challenging the commissioner's report here again?
No, you said that the 26(9) was never objected to them, objected to by them. 26(9) report. Yes.
Report, yes, that they have admitted in
Where is it?
para 10 of their written note also.
Yeah, written note to ठीक है, but
Written note,
before the court below.
the court below has observed.
Para 12 probably.
Para 11. It is in para 12, I suppose.
Para 12, yes, I've read it.
Yes,
What more to be argued?
that in page 10.
I've read it.
Yes,
What more remains to be argued? Only whether this finding is justified or not,
yes,
only to be seen.
yes. When there I say that when they have admitted that report, therefore there is nothing more to be argued here.
So
Because
to
it-
close it then. I'll
Well-
close it.
Yes,
Samantha, I'll close it. You have already filed your written note.
Yes,
I have also filed a written note that is on record.
Yes.
but that submission that I have admitted, that is I think
I'll find out.
paragraph
Admission
12
has to be
is there.
clear.
Paragraph 12 is also there.
Paragraph
But there, nothing has been mentioned.
I've read, just now I read it.
Yes.
Yes, paragraph
fine.
12 is.
I read it. You give a copy, Mr. Tripathi. Give a
Paragraph
copy.
जो last page 10 sir कहले written note रे ଟିକେ ପଢି ଦଉଛି ଲାଷ୍ଟ ପେଜ last page 10 of a written note.
Yes.
The second line, perhaps my learned senior is referring to that.
No.
The existence of the property is not in dispute.
No.
Moreover, the question is as to whether the property purchased by the plaintiff is the same as that of the spot. Because it is the question of, again, the question of recording of excess area comes in.
Excess area.
And how that has been, a new case has been pleaded before the Land and Lower Appellate Court. I will place only one paragraph of the Appellate Court judgment. The impugned judgment that is available. Available at page 6. The report is being examined. Then the last part of the page, the sentence beginning about the fourth line from the bottom to 8.
Yes.
PW8 means plaintiff's witness. In his evidence has stated at para 5 that the actual area which they had derived from those two cell deeds was much more than the extent of property mentioned in the two cell deeds. Here is a new story. That means they admit that the area was recorded in excess. Now they're coming forward
Not
that
my
even though we purchased less area, the actual area is much more. That was never the pleading. He has further stated in his cross-examination at so that his son and wife together had purchased an area of 90. What has been reflected in the cell deed? In his cross-examination he further stated that he cannot say with correct, and this is reflected in the commissioner's report. Because ultimately the proceeding, the record of right was challenged. Exhibit G-1, H-1. I have stated in my written note also. There is a clear finding that excess area was recorded, and ultimately the RR of the present defendant number 2 was held to be final. So that's all.
Only two things. First, what my learned friend said regarding that area and all that. That has been decided by this court, and it has been observed that unless it is rebutted, which is till today, it has not been rebutted. So therefore, that error stands because the Tahsildar has no power to rectify that. Number one. Number two, from the written statement, what my learned friend submitted, and the next line where he left, the next line, the description does not match with the property of the plaintiff. This is one. This can be, sorry, my lord, the previous line. The description which has been given, which he submitted, the same throws sufficient light on the question of identification. So that has been identified properly. And only one more thing, if your lordship finds that that report is correct, then I will say that the plot numbers which has been mentioned in that report tallies with my plot numbers which has been mentioned in the sale deeds.
Now, authorities applied the law of reservation to the post of GRS. The lordship wanted to know that how the social status of the existing by that date, how that could be determined. So I was directed to answer on that question. I have obtained that instruction. My lord, in the year 2013, my lord, a rule came into force, my lord, wherein in respect of the VLWs, 30% posts were reserved for the GRS.
This is VLW.
No, this is for the GRS.
So GRS, that account data entry.
No, that is in the year 2021.
This is for what?
Previously, my lord, another post.
Oh, this is GRS where it was single post was now made district cadre.
Yes, this is the case, my lord. My lord, in the year 2013, my lord, in order to answer your lordship's query on the last occasion, my lord, it has been pointed out that how the social status of those existing 90 employees, 90 GRS in that district was determined earlier. So, my lord, to that, my lord, my answer will be, my lord, that in the year 2013, after introduction of the statutory rule of with respect to recruitment to the post of VLWs, opportunity was created, my lord, for the existing GRS for being considered against 30% of the post. So, to regulate that particular process, government in Panchayat Raj department issued a resolution how to consider the cases of the GRS for their selection. So, on the basis of such instruction issued by the government, the district-wise GRS persons database was prepared, taking into consideration the government guideline of 2013. So, as on the date when this comprehensive guideline of 2018 came into picture, my lord, declaring that this is a district cadre, district as a unit, my lord. At a particular point of time, the database with respect to the social status of these different persons, the existing GRS, that is already available with the districts.
Constitution
So that is already available. So your lordship wanted to know that how we could reach to that particular social status of the existing persons. So this is the guide. This is the instruction manual which I have received, and in this case, my lord, that whether the advertisement which was issued with respect to the 19 number of the GRS in Subarnapur district, whether that can be filled up only by the reserve categories or not.
Mr. Patnaik,
Yes.
I was asking for the constitution. Representation, I'm sorry, reservation is provided originally by the constitution.
Yes.
Had there been no Article 15 or Article 16, there would have been no reservation. So reservation, the concept as I understand it, and I'm sure Mr. Mahathi, since it will be favoring him, so naturally he will also agree to it. There cannot be any sort of a deeming fiction kind of a thing, so far as applying the reservation is concerned. Some people are already in employment. You are now deeming as if they have been and they have entered into employment through reservation, which is not the case. You are only looking at their social category. Don't they never claimed reservation? They were, since it was a single post, reservation was redundant. It was never the question of reservation was absolutely redundant. So they never got into employment through any of the reservation.
Yes,
Provisions. All right. Now you are creating a fiction as if they had entered into employment through reservation. That is why you are segregating them on the basis of their, 22.5, 16.25, 11.25, and the shortfall you are advertising. My question straight away on the last occasion also,
Yes,
is it permissible? Retrospectively, creating a fiction.
We have not calculated their status retrospectively or by deeming provision. My answer would be
that is exactly what you have done. Otherwise, they were all single, they were all holders of single posts. So reservation was not there.
No.
Now you club them, you make them a district cadre.
Yes.
Right, you make them. Now you segregate them on the basis of their social categories and go in for the shortfall.
My lord, once the district cadre is district is to be treated as a unit, my lord. In that event, my lord, the persons who
Already in employment.
my lord, the unit is comprised of the vacancies as well as the persons who are already in employment.
True, very true.
So once both the categories of the persons are to be taken, the post vacancies are to be taken, then in that case, my lord, the persons who are already existing at the time of taking into consideration that whether they are properly representing that particular cadre or not, their social
So my question is, can you do that? My question is in this particular case, generally we are not on that. Nagaraj 2 speaks of post-based and not vacancy-based reservation.
Yes,
fine. But here, can it be applied? When originally reservation was not applied. You club them and you make them a different from a unit post, you make them a district cadre.
my lord, now, my lord, I may put a question to you. My lord, there are 19 number of vacancies for which, my lord, we put an advertisement. Then in that case, my lord, If in respect of these 19 number of vacancies, we cannot make any further advertisement for the UR category or SCBC category because they are already overrepresented.
On that day, I had given you an example, which I had done, but that was again a state level post.
Yes.
Yes, ma'am.
That was a state level post. So 15% were already on board. We calculated their social category, advertised the shortfall. Here, the difference is it's a single post that they were occupying earlier.
Yes, ma'am.
So that is a very, very peculiar and very touch and go kind of a thing. I don't think it can be so easily answered.
Then, my lord, the instruction which I have received.
Please pass it on. Sir, that is for a particular purpose.
Yes.
VLW, you were considering them.
Yes.
And in that process, you came to know about their social status.
No, my lord, your lordship, your lordship wanted to know that as on the date of the revised guideline was introduced in the year 2018, since rest to this 19 post out of the 109, since those are already occupied by the persons, how we could come to could come to know about their social status. So, my lord, to that, my lord, our answer is that the last page, my lord, that in order to comply the instructions issued by the government with respect to giving them a career progression by way of selecting them to the post of the VLW 30% quota, we had to follow the law of reservation. Because for the post of VLW, the proper representation through with ORB Act, my lord,
I don't think it is that simple, Mr. Patnaik, because originally, supposing in the case of reservation, what happens is, irrespective of the social category, a common merit list is usually prepared.
Yes.
Where, supposing a scheduled tribe person, he may compete on merit. He may be selected on merit.
Yes.
It is not as if a scheduled tribe candidate has been selected. It is an unreserved category candidate who has been selected.
Yes.
There are many such instances. Many such instances.
Yes.
In your with your experience in the service jurisprudence, you must be fully aware of it. So here, what will happen to that?
My lord,
That
in that event also, my lord, once a person has been selected under the social status, my lord, with a social status, with a social reservation, and got on merit, my lord, into the cadre, even if that, my lord, he never loses the status of that particular SC or ST. He is to be treated as SC or ST. But at the time of calculation and the filling of the vacancies, that shall not be taken into consideration.
You say that you prepared a gradation list.
Yes, ma'am.
Gradation list is something different. That is the interstate seniority.
Lordship, put me a specific question
Yes.
with respect
No,
to.
I'm saying you have given that, but that doesn't answer me.
I got to the knowledge of
I
the
don't think.
with that status, my lord, that we have the knowledge about the social status of the different existing persons. To that,
Even if they have not claimed employment through their social reservation, social categories.
because by that time, the law, even if, my lord, had there been an application of this ORB Act or rule, because it was a single post, it had no application.
It had no application.
Unless and until it has been made district cadre.
The only thing is
The
that
law
whether retrospective, that is the only question that we are going to
Yes,
decide here.
and my lord, another thing, there is a provision to apply the law of reservation even under the Act itself, MG Energy Act, my lord. Operational guidelines, my lord, that has been issued, my lord. There also there is a provision that the law of reservation applicable to the contractual post of the state government shall be made applicable to them.
All right, but that will be prospective.
My lord, say jo prospective जोटा दिया है जी, जो 2013 रो say guideline that is in force, and my lord, that is what, my lord, we have clarified in that taking into consideration all these, the district authorities were directed to prepare the database, and they had prepared the database. And
Yeah,
in the
database
meantime-
is fine. Database is fine. We get to know to what category a particular
Yes,
person belongs.
yes.
But knowing his category is one part. Saying that he is deemed to have been appointed under that category is another part.
But my lord, once the persons who are already existing with different type of social status, and now the post-based reservation, if it will be applicable.
Because had there been a reservation,
Yes, sir.
what would have happened? He may not have got employment. Somebody else may have got employment because claiming
That is, we are
So we
applying
don't know.
prospectively. We have never applied it retrospectively. We have applied it prospectively. Now,
Difficult question.
vacancies which are there, only we are taking the law into course, my lord, that reservation law into course, only with respect to those posts.
I will
Vacancies.
request some senior counsel not connected with this case to address this court.
Yes.
What do you say? Mr. Mahathi, not that you are, I am not that I am doubting your
Your
competence.
lordship's discretion to
But-
appoint anybody
no,
as a habeas corpus.
But this is a larger question.
Yes.
Why not the Advocate General address the court on this issue?
I will.
Yes, Mr. Das, you are appearing in all these Sevak matters?
Yes,
Huh?
I'll request the Lord Advocate General.
Yes, I will pass that order.
My lord may appoint any, my lord, since advocate, my lord, I don't have it. I cannot stand in lordship's way. Your lords may ask for any learned senior advocates of this honorable court as an amicus.
Because here already a senior counsel is appearing in one of the matters. Mr. Rautra.
He is there. So you may
I cannot appoint him. Normally I would have appointed.
other than him, your lordship, as per your lordship.
Kunati.
My lord, it is your lordship's discretion.
So we will ask Mr. Bibisar Das to suggest one name. He is not connected with this case at all. So let him suggest. Any senior counsel except just Mr. Budhar Rautra because he is appearing in one of the cases. All right. But I will request the Advocate General to also.
Yes. खाली टिके गोटे कथा टिके आपण नॉलेज को आनिबी
Please.
सर से जो टिके सर तांकरी काउंटर से गाइडलाइन तो टिके देखो पेज 26 का आगे सीधा है सर पेज 26 of your lordship's brief.
Yes.
Last line. These guidelines supersedes all previous instruction and is given effect to immediately.
Page 26, sir.
Yes, the very guideline under which the post has the application of ORV has been dragged in. So also the district cadre, this has been given prospective effect. Whatever attempt they are making, my lord, what it ultimately leads to is retrospectively applying or treating the cadre as a district cadre by clubbing all these posts. One. Second, my lord, applying that ORV Act retrospectively. My lord, I am putting a question to myself, my lord. If at all such an attempt, whatever they are contemplating, is allowed to proceed further, then they will themselves land up in trouble because Section 12A of the ORV Act will stare at them. The moment they will make it retrospective by applying the entire cadre, the ORV Act to the entire cadre, all those appointments made during the entire period is voidable. Because that has been said to be so. So I am just reading for your lordship's perusal. Your lordship, Section 12A. Irregular appointments to be voidable. All appointments made in contravention of these provisions of this Act, ORV Act 1975.
Yes, sir.
All appointments made in contravention of the provisions of this Act after the commencement of the ORV Amendment Act 1982 shall be treated as voidable. So all these excess appointment, whatever they call, my lord.
It has to be proved. First, there has to be a finding that
Second thing, as your lordship have rightly said, all those SC/ST people who were appointed, my lord, once they will be treated as occupying SC/ST post under the present dispensation, whatever they are now calculating, that means they are being assigned as per the caste to which they belong. In whatever they are finding on fact is, there are 25% suppose belonging to ST already in place. That means those STs who are already in place are being adjusted against ST category post, even if they were originally.
Mr. Mahathi, he has an answer to this. According to Mr. Patnaik, if I have understood him correctly, he says that generally this percentage of reservation is to find out whether this percentage of the that particular category has been represented or not.
My lord,
in the total scheme of things,
yes.
This is a scheme of things.
My lord, what they
So 22.5% need to be filled up by scheduled castes and scheduled tribes. 16.25 by scheduled castes and 11.25 by SCBs.
My lord.
So the endeavor to see that
my lord,
these persons have been represented.
Once they are permitted to do so means They are implementing this district.
I'm not saying that. I'm not saying that. I'm not saying that.
No, my interpretation to their submission is once they are permitted to do so, amounts to applying this decision to make it district cadre retrospectively from the day all these appointments were made. One, and applying this ORV Act retrospectively from that date because all these posts were, you must kindly see, once ORV Act will be made applicable retrospectively, that will lead to different consequences. Your Lordship is well aware about the maintenance of a roster. Have they maintained it? They
Could not have.
They don't have. They could not have.
They could not.
They could not have. So this is an attempt they are making. Well, one more thing your Lordship may kindly see. They are applying. I have argued it is at the cost of repetition. I am just recapitulating your Lordship's memory. But by virtue of a guideline, the very annexure 4 itself at the marginal heading says it's a comprehensive guideline, means it is just compilation of different instructions issued at different point of time. Well, by issuance of a guideline, which as it is from the very nature of its legislation is prospective in nature, but what they are intending to do is overriding a statutory the act framed under a competent state legislature where the applicability has been exclusively excluded.
All right. Heard arguments in part. From the rival contentions, this court finds that the crux of the dispute lies in the fact that the Gram Rozgar Sevaks who were initially appointed against single posts have now been treated as reserved category candidates in view of the posts being transformed into district category. The question is, whether the principles of reservation can be applied retrospectively to the existing employees who did not secure employment on the basis of reservation. Further, is it open to the authorities to apply the principle of reservation by simply considering these social categories to which the existing employees belong? Considering the importance of the issue involved,
Can I suggest, my lord, two names, my lord? My lord, may think of either senior counsel Gautam Mishra or senior counsel Pomirat, who usually deals with all popular.
Mr.
Pomirat or Gautam Mishra, who usually do.
POMMY?
I am my.
সেটা কৌন তো
ওড়িয়া মিডিয়াম পিলা মোর
ওড়িয়া মিডিয়াম পিলার নাটা আছে আপনার বিশ্ববিহারীটাকে বিশ্ববিহারী কই পর্যন্ত না মোর নাটা আপনার অন্য কল্পনা
সরি
এটা বন্ধ করুন মিস রথ এন্ড গৌতম মিশ্র
As your lordship, it is up to your lordship because your lordship, it's a point to be considered because it's a thing which will have ramifications.
We can ask both.
Your lordship.
Considering the importance of the issue involved, this court would like to have the assistance of senior counsel with the consent of the parties. Sri Prafullo Kumar Ratha, learned senior counsel, and Ms. Prami Ratha are requested to assist the court from the side of the petitioners. Similarly, this court also requests learned Advocate General to address the court in view of the importance of the issue. Yes, this is very important. This will, I think, have a very wider ramifications, Mr. Das. Please, this matter. Let adequate copies of the brief be handed over to be supplied to the supplied by the office to the senior counsel, release this matter the week for it.
ଟାଇମ ଦେଇକି ଦିଅନ୍ତୁ କାରଣ ସେମାନେ ମଧ୍ୟ ପଢିବେ ମୁଁ ମାନେ ମୋ ଆମର ଆଇ ଡୋଣ୍ଟ ନିଡ
No, no,
ଟାଇମ ମାନେ because they need
Mr. Maruti, no, no. It's all right. We'll take it upon 2nd September.
ଆଜ୍ଞା
May be permitted, madam. Because I have submitted that instruction in terms of your lordship's direction on the last occasion. So may I be permitted to file an affidavit to that effect, bringing all these things, madam, in the pleading.
Correct. Then State Council is permitted to file an affidavit incorporating the instructions received by him pursuant to direction of this court. Yes.
serving copies of
Yes,
the
sir. Affidavit, they give it some.
Yes. A very interesting issue. Let us see how far we go. Because you see, I know Nagaraj is hanging very heavy on your heads, both of you. Nagaraj. But whether it can be, Nagaraj, post-based, not vacancy-based.
Post started with R.K. Saurwal, 1995 Supreme
But
Court.
it has been crystallized, I think, in Nagaraj.
Good law by the constitutional bench judgment in M.
So basically,
Right.
no, Nagaraj is also constitutional.
Yes, that is also constitutional.
Second, Nagaraj too.
Right.
Okay.
Item 8. I may be permitted to make my submission on behalf of my learned senior.
Yes,
3 interim applications are there before your.
397, 396, 398.
Yes.
When did he die?
Sometimes in the year 2010. Respondent number 2 sometimes in the year 2010 and respondent number 4 sometimes in the year 2006. Man.
Yeah, you argue on merit. If there is any material, then we will think of substitution, otherwise go.
Lady married. She was living with her son in Gujarat.
So you are not ready today.
No, I'm not.
All right, all right.
The notice may be. There is a delay, married.
Oh, why should I issue notice? If I am not convinced about the arguability of the appeal, why should I? Yes, Mr. Das.
Your lordship.
Oh, it's a huge delay, 10 years or more.
I understand.
So, yes,
There is a reason, but behind. It's completely not in know of the.
well, then let us issue notice on all the IAs. Hala, IA oda sab likhi debe. Issue notice to the PLRs by registered post with AD, returnable within 4 weeks, requisites be filed within 3 working days. Place this matter. 30th September.
Published.
In the week commencing 30th. In the week commencing.
I do not 10.
Mahapatra is yours. All right, pass over.
I don't know 11.
Please. Date that is there, that's the kindly.
Yes. What is your prayer, sir? Yes, no, item 10, I have just passed it over.
My prayer is for quashing of the order where they have rejected the claim of the petitioners. For that order dated 8/7/2013 as annexure 17, that was challenged in this writ application. There is some little background I'll show you. Then
We'll go to the date chart.
yes,
Yes.
date chart. Let's get it. Date of effect.
Yes.
89, the petitioner schools, namely Pokharisai Primary School, District Mayurbhanj, was established.
Sir,
From 95 to 2001.
just a moment. Sir, this is item 11, though?
Item 11.
Sudhan Thanapati?
Yes.
89, yes. I had opened the wrong file.
Sorry.
Yes, 89.
Yes. 89, the petitioner schools, namely Pokhari Primary Schools, District Mayurbhanj, was established. 95-2001, the petitioner for assistant teacher after following due procedure of law. Then 7/5/2001, a proposal was sent by the District Inspector of School Authority to Deputy Director for taking over the management of the school. That is annexure 3 at page 23. 17/7/2004, after due inspection, report was submitted by BRCC, Betonati, to DPC, Mayurbhanj, Baripada, wherein it has been recommended the petitioner's primary school along with his staff to be considered as regular government employees. This is a report submitted by BRCC. Then 6/4/2005, the opposite party number 4 ordered to open Pokharisai new primary school in the Betonati block. Then
Respect of another school, Kopamundu Primary School, who had approached this honorable court, it was skip over, I'll come later on. And pursuant to this order in 2005, on 13/6/2006, this Kopamundu Primary School was taken over. It was a skip over this serial number 6 and 7.
Yes.
Then serial number 8. For the first time, one teacher, namely Ratna Manjari Swans Bhanjari Ubahu, was sent on deputation to Pukurisai new primary school under Swanso Gram Panchayat. Then 25/8/2009, DPC directed the BRCC authority to submit a report. To the request, report was sought for by OPEPA, OP number 6 from OP number 4, regarding teachers engaged in Pukurisai Primary School for taking necessary action in the matter. That is Annexure 12. 27/1/2010, DPC submitted report for taking over the management of the petitioner school. Then on 2/3/2010, Deputy Director Planning called for a report from the District Inspector of School Veterinary regarding the status of the petitioner school and position of the teachers. Kindly see Annexure 13. Then 17/4/2010, District Inspector of School submitted a detailed report to the Deputy Director revealing the detailed staff position and the genuine grievance of the petitioner. Petitioner are all the staffs. Then 24/11/2010, an order was passed by this Honorable Court. They approved this Honorable Court in 2010, wherein directing the state government to consider the case of the petitioner schools. Then no action was taken. The petitioner filed a contempt application in 2011. On 76/2011, order was passed by the government by filing a show cause in the contempt application, where it is indicated that proposal for rehabilitation of displaced teachers of the said school is under examination and decision will be taken after due approval of the finance department. Then 8/7/2013, 2 years after, OP number 1, without applying its mind and without sending the proposal for approval to the finance department, rejected the case of the petition. That is what the subject. But in the meantime, another case, of course, incidentally, I was at council. Of course, though the fact, that is a case also taking over of primary schools. But before that, may I take a receipt on affidavit I have filed. Along with the affidavit, one, the circular of the state government that by the order of the governor, the decision policy decision of the government so far as taking over of the primary schools are concerned. That is at the last time already recorded, yes. Let's get it.
Annexure 18.
No, that yes, Annexure 18, you're correct. Annexure 18, let's see, on 22nd April 1997. This is the policy decision of the state government taking over the management of Swanso. In another case, part of the policy it has been said, the new educational policy has laid stress on the universalization of primary education. As the primary teacher laid the foundation of the education, that is justification for improvement of their service condition. Accordingly, government have declared all the primary school, let's mark it, to chairs of the schools managed by the Panchayat Samiti and non-government primary school as well as urban local bodies and of the school directly administered by the district inspector of school and the assistant teacher, headmaster of UGME school as government servants with effect from 5th September 1989. An uniform system in the primary education of the state government decided to take over the management of the primary schools established by the volunteer agency and other non-government organizations and imparting the same education as per the syllabus of the school and mass education department. Keeping in view the above principle and approach by the management of Sishu Vidya Mandir, another school, Bargarh government have decided to take over the management of the above primary school in the district of Bargarh, imparting the same primary education to the student as per the syllabus of the school and mass education department with effect from the date actually take over by the district institute. Subject to the following condition. 1. Government would not be liable to clear any liability whatsoever relating to period prior to and or as on after the date of taking over incurred by the management of the school. Then 2 is only such of the employees are justified as per the yardstick prescribed by government shall be accepted. The service condition of these teachers shall be regulated by the government as a government servant from the date of actual discharge. Then the next, come to the judge. Yes, we also come to Annexure 19.
Yes.
Another matter, Orient Colliery ME School, Brajraj Nagar, where the matter was carried to the Honorable Supreme Court at the instance of Mahanadi Coalfield, because that was a case also taken over by the government. Having heard on counsel on both sides and learned additional Solicitor General appearing on behalf of the petitioner, we are of the view that the action of the state of Orissa in not taking over the Orient Koreari Hindi primary school is not sustainable. In the peculiar fact and circumstance of this case, and particularly when the Orient primary schools has been taken over. We also note from the judgment of the High Court that at present all the primary schools in the state are taken over by the state government. We therefore direct the state of Orissa to take over Orient Koreari primary schools with effect from so and so the direction will. So now the whole question is here admittedly the school was opened in 1989 and these petitioners were appointed way back in 95 to 98 like this. And they were appointed as per the yardstick. There is also no dispute because they have not denied that. And a proposal was sent by the district inspector of schools since the government decided to open new school, why the school will not be taken over and why the teachers will not be observed in that school. And by this process, there are various correspondence made in the process. Then when the petitioner approached this court directed that to consider their case. By considering they did not, so contempt application was filed. In the contempt, they filed a show cause saying that we are taking action. Then they rejected it.
Let us see the impugned order.
That's right. Also kindly come to the impugned order. That is at Annexure 17. At page 52.
Yes.
Pursuant to direction of the Honorable High Court in so and so filed by Sudham Chandra Sanapati, these petitioners. The opposite party number 1 has examined the grievance of the petitioner in accordance with law by passing appropriate reason order, bearing so and so communicate to all concerned. As per the para 3 of the order, the proposal of the collector cum chairman SSA Mayurbhanj received through Director of Elementary Education for rehabilitation of teachers of the school in question as Sikhas Act. In 2002, for the first time, they introduced the Sikhas Act. Earlier, the primary school that in 97 they made a resolution, then Sikha Karmi or something, then Sikhas Act. So, as per the para 3 of the order, the proposal for collector for rehabilitation of teacher of the school in question as Sikhas Act has been considered by the OP number 1 and decided as follows. In Sarva Shiksha Abhiyan, there is no provision for taking over the private management school. A new school might have been declared to provide the benefit of SSA to the student. SSA means Shiksha Service. I think. SSA. Sarva Shiksha Abhiyan. SSA will take care of the students and infrastructure, but teacher cannot be taken over as it involves the larger finance and other implications. Considering the welfare of students and all SSA benefit will be extended to the school, including infrastructure. DIF school Betonati Mayurbhanj to post the regular teacher from the existing pool. Then next is important. The teaching and non-teaching staff cannot be taken over on humanitarian ground. Only age relaxation can be considered with the approval of the finance department. No precedent cannot be quoted as a, because precedent is other schools they have taken over. They say no precedent cannot be quoted as a situation. Government might have taken a view in case of Gopabandhu Primary School, Bharatpur. This is only exceptional and not the norms. In view of the above, the proposal of rehabilitation of teacher of the school in question as Sikhas Act has no merit for consideration. This is the improved order. And recently a judgment of a coordinate bench, of course, in that case, though similar question arises for taking over, but they have already taken a decision to engage them as Sikhas Act and subsequently to regularize them after 6 years as a junior teacher and regular teacher. But they recall that order on the ground that this may be precedent for other. That's the challenge. And a coordinate bench of this Honorable Court was a recent judgment. 14. And this is a case of 2013. Present one is 2013. His Lordship has even called for the entire file, and I think they also kindly come to page 2, the factual background of that case. I'm just in Sikhar Chandi UP school. This is in Bhubaneswar. In 90 Sikhar Chandi UPM school. Let's get it.
At page
2. Internal page 2, paragraph 2.
Yes.
In 1990, Sikhar Chandi UPM school was on 25/3/94. The managing committee of the school requested the Bhubaneswar Municipal Corporation to take over the school. Bhubaneswar Municipal Corporation decided to take over the management of the school. Accordingly, passed various resolutions so and so. On 13/11/2000, the Chief Executive Officer informed the government about taking over the management of the petitioner school by the Bhubaneswar Municipal Corporation, and an amount of ₹4 lakhs was sanctioned. Then on 23/1/2003, an advertisement was issued by the government to open new primary and upper primary school. On 30/7/2008, the state government decided to take over the school and include it under the Sarva Shiksha Abhiyan, herein after short SSS scheme, and declare the school as primary school, project primary schools. On 21/8/2008, the managing committee of the school passed a resolution to hand over the school building management staff to the district project coordinator, Orissa Primary Education Program Authority, OPEPA, Khurda, OP number 5. On 16/2/2008, the untrained teachers were directed by the OP number 1 to avail in service training and acquire the teachers training qualification. Here the petitioners are all qualified. On 23/12/2008, petitioner along with other employees made a representation for taking over the management of the petitioner school. And since no action was taken, some of the employees of the teachers of the school approached the school by filing a writ application of 2008. The said writ application was disposed of by order 22/2009, wherein the petitioners were directed to file representation before the director of OPEPA within a period of 6 weeks with all relevant documents, and upon receipt of such representation, the opposite party was directed to pass necessary order within 4 months. The relevant portion of the order is quoted below. Let's just skip over because that is a consideration, direction was consideration. Then we come to page 4, para 2.2. Pursuant to the order passed by this court, the opposite party number 2 directed the district project coordinator to conduct a joint inquiry and take necessary action in accordance with the report of the joint inquiry and the decision taken in the committee meeting. Then on 4/6/2000, District Inspector of School Bhubaneswar issued a letter for consideration for absorption of the petitioner's case act. On 6/9/2011, the High Power Committee, after due deliberation and consideration pursuant to the order of the High Court, recommended to take over the management of the petitioner school with the observation to observe the teacher as Shiksha Act with effect from 30/7/2008, that is the date of declaration of the school as a project primary school. On 7/2/2013, Annexure 17 series, the government in the department communicated decision to take over the management of the petitioner school and declare the said school as project upper primary school under SSA. Subsequently, another letter was issued on 19/3/2013, wherein this project upper primary school under SSA. On 14/5/2013, decision was taken by the government to observe the teacher then working in the petitioner institution as Shiksha Act, trained and untrained, and 2 untrained teachers were allowed to undergo the service teachers training in the year 2013-14. On 25/11/2013, as per the report of the joint inquiry conducted by the opposite party, the trained teacher of Sikharchandi UPM ME school were recommended to be observed as Shiksha Act, and the untrained teacher were to be observed after acquiring the training qualification within 3 years. Somehow, the matter was set for reconsideration, and on 14/2/2014, the High Power Committee constituted by government recommended for absorption of trained teachers for petitioner school as Shiksha Act with effect from 30/7/2008, and the untrained teacher as Shiksha Act after acquiring the teachers training qualification on 1/4/2015. On 36/2014, while the matter stood thus, the OP number 1 passed an order recalling the earlier order 7/2/2013 and 19/3/2013 purportedly on the basis of the decision passed in civil appeal, another civil appeal number so and so. Earlier on 27/2/2007, in the case of similar school, that is Gopabandhu Primary School at Bharatpur, Khurda, the state government had not only taken over the school, but also allowed the existing staff to continue as Shiksha Act. Then pleading upon behalf of the opposite party, then the coordinate bench has allowed the application and passed the order of recall and directed to observe. This
Here it was never considered. It was in your case
it was considered rejected.
It was rejected. Actually.
Rejected.
They
are also this rejected, referring to judgment order of the Supreme Court. In one case, Supreme Court has said that it is not the right of the person to claim that has nothing to do with this. Rather, Supreme Court orient that colliery case which I just now placed, that once you have taken a decision to take over all the management of the school, then how can you now make a departure so far that school is concerned?
Yes. What is the stand? Then we'll continue to next week. We'll continue next week.
Yes.
Huh.
I will have to discuss with the authority in view of this.
The point is very simple. Actually, the point is very simple.
Yes.
You have heard the senior counsel. He is referred to the education policy of the state. In the previous order relating to
several other instances.
Relating to Saraswati Sikham, what is that? Saraswati Sishu Mandir.
Yes.
And Gopabandhu school, where the education policy was that all primary schools will be taken over.
Yeah, that was
If that was the bias intent was the pious intention of the state, then why will it make a
further
discrimination?
discussion with the authorities is required to adopt the
Yes,
present
heard in part.
petitioner's case.
But in partly, is this matter when do you want? Only this point.
Next week, anything?
Week commencing 27.
Or leave this matter on 27th of on 27th. Yes.
Item 12.
Regarding disengagement of GRS by the
Wait. Notice on opposite party number 5. Tracking report could not be obtained. Who's opposite party number 5? The private opposite party.
It's a Sarpanch. Perhaps 5 is the Sarpanch.
You are challenging his order.
No, my lord. Challenge the order of the collector.
So if you continue with opposite party number 5, then you have to take fresh notice. Otherwise, you may delete him at your own risk.
No, already notice has been issued.
Notice has been issued, sir, but notice has not been. There is no proof that it was served upon him. So unless there is sufficiency of.
I have to file press requisition.
Okay. Requisites for issue of fresh notice on opposite party number 5 be filed within 3 weeks, within 3 days. Notice be issued by registered post, fixing a short returnable date. List this matter on
10 September. 10 September.
10 September. Yes.
Interim order.
Interim order to continue.
Item 13.
Counter not files.
Yes. You have taken time to file counter. That was in 2022. Is your salary being released?
No. He is not allowed to continue and salary also not released.
No. You said by order dated 2/8/2022, basing on your submission that you are working as per on the basis of the interim order. This order was passed.
Last month. That one.
Yes, counter.
But the file has been misplaced somewhere. It has not been supplied to us.
Land State Council requests for an adjournment on the ground that the file has been misplaced in his office. And stop. Let's this matter on. Applicable. 3rd September. Yes. Counter be filed in the meantime.
Item 14.
This is a matter
Yes.
disengagement of the Anganwadi worker.
Yes.
But this case I filed 2 miscases on stay and amendment. But today I'm filing this consolidated petition.
Amendment was allowed.
No, my lord.
Amendment has not been allowed. Why are you
yes,
filing the consolidated? Let us see
Yes.
what is the
But
amendment.
yes, amendment, but this is a matter related to the
IA number?
the I number. Just a minute. I number 9806.
Yes. What is the you want?
During pendence of the writ application, now they have issued another notification for filling of that post. That is a file.
Alright. Yes.
Let it be allowed.
Yes. Therefore, amendment of the writ application has been made on the ground that during pendency of the writ application, a notification has been issued by the CDP of Gondia on 24/7/2024 for engagement of Anganwadi worker in Kaluria case center.
Okay, yes.
Since the material bearing on the present case, the petitioner wants to incorporate said fact in the writ application. Then at State Council does not have any serious objection to the amendment being allowed. In such view of the matter, the IA is allowed. Consolidated writ application has already been filed in the court copy of which
Yes, already served.
has also been served on the State Council. Yes,
Yes. Here, if the petitioner has filed his application challenging the order of disengagement,
you have filed your counter in this case. Everything is ready.
the counter they have not filed. The
Yeah,
counter,
counter update by 2, 3, 4, 5, and 6. Yes, sir, I think CDPO has filed counter on behalf of everybody. I think that should suffice.
So 2 to 5 have, 2 to 6 have.
Now we'll stay this notification and we'll hear this matter.
yes, copy of the
IA 9806 of 2024. Since the order of the collector dated 24/9/2019, the date कितने से था? Final order टा कितने?
that is 24/7 to 24.
नहीं नहीं क्या? Original जी impugned order टा कितने?
Is
8/1/2021.
Yes, collector's order. That is yes, 8 to 21.
In disengaging the petitioner is under challenge before this court in the present application, and pleadings are and the matter is otherwise ready for final disposal, with pleadings being complete. Stop. It would not be proper for the post in question to be filled up afresh. Stop. In such view of the matter, this court directs that operation of the notification dated 24/7/2024 passed by the CDPO Gondia shall remain stayed till the next date. Place this matter for final disposal. I read to record you.
10 September.
Hmm.
10 September.
On 10th September.
But a copy of the counter may be served by that, not served on me. Copy.
After the amendment, if necessary, further.
Yes, yes, yes.
It shall be open to the State Council it shall be open to the state to file further counter to the amended rate application.
Urgent copy.
Urgent copy of this order be granted.
Item number 15.
Item number 15, I pray for an adjournment, my lord. Maybe it come tomorrow. I mean, instructed my senior.
Tomorrow. All right.
Senior counsel, Sri Kali Prasanna.
Several times that.
No. Last occasion, my lord has already kept the date for
Inclusive today, it has become.
Today he's engaged in another code. He's a
Who is your senior?
Kali Prasanna Mishra, my lord. He should appear in this one.
Prayer for adjournment is made on behalf of the petitioner, which is seriously objected to by Sri H.N. Mahapatra and counsel for the opposite party. List this matter tomorrow.
But a similar matter, so item 5, which has already been passed over.
Add one word for last sentence.
What?
Parties are requested to come ready for final disposal.
Your lordship may say last chance, if any adjournment.
It is made clear that no further adjournment shall be granted.
Deeply obliged.
Item 5 also, I mean, passed over for another adjournment item.
Item 5 be tomorrow. Yes.
Number 16.
This case, I have challenged the order of the appellate authority.
I am appearing for the OP 5 minutes. I have not filed the counter. 2 weeks time may be given to file the counter.
I submit, he is the beneficiary of the order passed by the appellate authority. By virtue of appellate authority order, I have been disengaged and he has got appointed. The notice has been issued since long and the matter has been.
I will grant her 1 week opportunity. All right. You are Miss Mishra.
Yes, let's.
Government has filed counters, but there is no need to file regenerate on the
Professional reasons. Rajalakshmi Mishra requests for a time to file counter. So 1 week time is allowed. Let's this matter on 27th August. Counter if any be filed by the opposite party number 5 in the meantime.
obliged.
Item number 17.
May I please, your lordship?
Well, in this case, I'm official counter on 29/7, but that is not on record. That is, there is a noting mail.
Counter नहीं आया
Asking,
counter नहीं आया ହେଲା କାଲି କି ନାହିଁ take it up tomorrow
next week asu.
କାଇଁ କାଲି
Region ରେ ଦେଇଦେଲେ ବି ଏକାଥରେ state ର region ରେ ଦେବେ ମତେ region ରେ ଦେବେ.
Made a statement, my lord, it completely law is involved in it.
ଯଦି ଦରକାର ହବ ଆଉ ଟାଇମ୍ ଦବା କଣ ସେମିତି କିଛି ନାହିଁ this is matter tomorrow along with the counter affidavit filed by opposite party number 7 yes
Next week asu. Verify କରିବାର ଅଛି କିଛି ଜିନିଷ verify ଅଛି ମୋର.
next week
Date what is that?
next week 30th
Interim order may be.
interim order to continue
Okay.
item number 18
May I please, I'm appearing in this case today. And the similar matters, my lord.
for the petitioner
My lord.
you are appearing for the petitioner Mr. Pandey
My lords. And
you have obtained the no objection from the previous counsel
yes, my lord. No objection. I am not signing.
no objection
मैं साइन करने कर दे दो चाची फाइल कर दो आज कर दो
ସେମିତି ନହେଲେ କେମିତି ହବ Mr. Pandey all right Sri A.K. Pandey Leonard counsel
instruction to appear and my lord
I say that Sri A.K. Pandey Leonard the counsel submits that he has instructions to appear on behalf of the petitioner and that he would file wakalatnama after obtaining no objection of the previous counsel.
one more prayer my lord the WPC number 21890 of 2013 and 21891 and 21893 of 2000 these are similar matters my lord where counter result everything has been filed. Look at my lord tagged with this one
List this matter along with so and so.
2013.
List this matter on third September with so and so so and so.
My lord, sir, all result you are can hearing this matter also, but a similar matter to this.
I am for opinion number 1.
So 18 number to the.
Item 19.
May I click my lords? My lords, before proceeding in the case, I must submit that after notice was issued, state government has already filed a counter. I filed a rejoinder. Nobody was appearing for the selected candidate. Today, one name has come. So, if they want to file a counter, if your lordship permits them, then why to spoil your lordship's time?
Yes.
It took some time to file the counter, my lord.
Early देले भलो होता बहुत पूर्ण.
So for the opposite party number 5 seeks some time to file counter. Will is this matter? 10 September. On 10th September, counter affidavit would be filed in the meantime.
Lordship, the state has filed the counter, the copy may be sought.
ସେ ମୁଁ କଣ କରିବି ସେ ତାଙ୍କ ମାଗିବେ ସେ ଦେବେ ନା ମୁଁ କଣ କରିବି ମୁଁ କଣ ଯାଇକି ତାଙ୍କଠୁ ଓହ୍ଲେଇକି ଯିବି ତାଙ୍କଠୁ ଆଣିବି ଗୋଟେ ଆପଣଙ୍କୁ ଦେଇଦେବି ଯଦି ମନା କରିବେ କେହି ଆପଣଙ୍କ ଗୋଟେ ଜୁଡିସିଆଲ ଅର୍ଡର ସେଥିପାଇଁ ଦରକାର ବାଇ ଦି ହାଇକୋର୍ଟ Mr. Patak is a fair person. I don't think he will.
I think, my lord, there are two counters from our side, my lord, whether
Two counters. I have received one.
देखिए yes item 20
It has been posted to September.
हाँ से डेटा कहले ଆପଣ yes item 20 पासवर्ड करे सफा करे item 21 ଏଟା କାଲି ଥିଲା କି କାଲି ଥିଲା all right ପାସवर्ड item 22 yes Mr. Mahapatra
I have taken instruction from the lower court advocate.
yes
He said that the civil proceeding has been dismissed for default.
Sorry, dismissed as infructuous or what?
Liberty, my lord, if it will be restored again, my lord, I will be.
So why don't you seek withdrawal then? Withdrawal with liberty.
My lord.
That will be better.
My lord.
Learned counsel for the petitioner seeks withdrawal.
No, your lordship, my instruction may be.
All right. Sri Mahapatra, learned counsel for the petitioner submits that the case sought to be transferred has in the meantime been dismissed for non-prosecution in the court below. As such, the transfer application has become infructuous and is disposed of as such, leaving it open to the petitioner to approach this court, filing a leaving it open to the court to file a better application, and if I took leaving it open to the petitioner to approach this court in case the order of the court below is subsequently modified.
Item 23.
23. Pass over. 24.
Item 24.
Petitioner not it pass over koriya dekhe.
Item 25.
Matter.
25, I am appearing.
Yes, Mr.
TRP.
You have filed a CRP. This is not the CRP, my lord. This is a CP.
CP.
No, he's right. He's right. This is CP 54 of 2000.
But
Yes,
when
CRP.
this honorable court directed the one of the case to be tried at that Jaipur, then he seeks a
No, that can be taken note of. That can be taken note of, but it is not about the suppression. No. Case ta alga hoche na. Case ta alga hegale. It is open. I mean, he may say, he may not say.
well.
Had he said, it would have been a better thing. It would have been more transparent. But that will not lead the court to, I mean, persuade the court to hold that it is a.
What is when this
But then leaving aside all these
and
things.
this order was remained unchallenged.
No, Mr. Das, leaving aside all these things, with whether the parties would be agreeable for settlement.
Yes, Miller, the settlement at mediation center at Kotak.
High Court in course of hearing, it is stated at the bar that the dispute between the parties is mediation to order kar This is matter. Masse pare 30th September.
Further proceeding be stayed. से गोटे ऑर्डर कौन पास कर दे जयपुर रे
आइए टा कहीं दउना थी आइए आइए कोन करबे
ओरल
मूलरू काउंसलिंग आर
द इंटरेस्ट ऑफ
ओरल प्रेयर मु ओरल ऑर्डर करछि तले इन द मीन टाइम एडजर्नमेंट
माय नेम में भी करेक्टेड लॉर्डशिप में काइंडली
एडजर्नमेंट करबे
लेट इट
No, if you need an adjournment, you will move for adjournment. That will be allowed by the court.
mediation center
अरे आप बुझुना दी कथा सेठी adjournment मांगले it will be automatically adjourned in view of the pendency of this case.
सेठी की जयपुर के जीवन जाय ए पिला जाउनी नक्सल ताको गोटे देछि नक्सल लगे की मार दो बोली बाड़ी छि भी ताको सही कोर्ट रे जाइतला नक्सल भरटा बेसी अछि पिटिशन
अरे
तो मार होइछि
नक्सल लगे की मार दो
धमक देछि सेथि से
नहीं नहीं मुझे सीधे पचास नक्सल टे लगे की मार दो अरे
Annexure 5 is the FIR report in Jaipur police station and there is a case registered in Jaipur police station.
ये बंद कर दो
गुड 13 September mediation.
Masse. Yes.
Yes, ma'am. Item 26, I am for petitioner.
Who's for the opposite party?
Yesterday also.
Yesterday, just a one passover. I mean, short adjournment. Just a one passover. I mean, short adjournment. I mean, next week. Next week. Item 28.
28, my lord. I pray, my lord, let this matter come along with TRPC number 120 of 2024.
All right. This matter next week along with TRPC number
120 of 2024.
120 of 2024. Yes, item 29.
Interim order to continue. Interim order to continue in 28, my lord.
They filed this petition for transfer of the CP pending before the Kotak jurisdiction.
Who's appearing for the other side? You are appearing? Is there any chance of settlement, sir?
Sir, I am agree.
You are agreeable?
Sir, I am ready.
No, sir.
One chance may be given, honorable court may try. Both
If the
may be-
lady is agreeable, why not have a? Just explore the possibility. No, I'm not forcing you.
Yeah.
I'm not forcing you. No, the court will never force you to have a mediation. But in all these matrimonial matters, mediation is always open, conciliation. So why not you make it?
Both should come and appear before this.
No, not before this court.
Sit.
Go to the mediation center, High Court mediation center. Mediation court. Then order कर देगी mediation center करते हैं. This matter on
30th September.
there.
It is.
Please, 30th September. It will come in the meantime. Mediation no notice file अपने जुड़े.
Item 30.
30 yes.
Sir,
Of notice by society received by his sister in the absence of the addressee.
Repudiate file for special messenger matter.
Yes. Since notice was received by the sister of the opposite party, the same is treated to be sufficient. The joint living sister. Yes. There is, however, no appearance. In order to give one more opportunity, let's this matter next week.
Sure.
Next week. Is there any interim order? Interim order to consider?
Adjournment, please.
Adjournment.
Item 31.
On behalf of Canon.
On behalf of Canon Government?
Sorry, senior Milan. Sorry.
What Canon Government? Milan Government.
Senior.
Dita को जोड़ू ना दिया हाँ दीटा को जोड़ी दिया तो पाठर मैटर सा लॉन्च पर हमारा अच्छी ने ओ था all right pass out item 32 no one 33 yes Mr. Vajadev yes your matter.
Yesterday, Lordship directed to list the matter along with CRLMC number 991 of 2000. Yes, madam. Here in this case, your Lordship has challenging the order of cognizance. But in the 161 statement, he has stated no matter regarding that is page 20.
Not in just a moment.
And
there it was directed that you may move.
And
but what is the prayer there?
In the first
you had
in the first instance,
no, you had asked for postment of the order of cognizance.
Yes, madam.
As well as direction of appearance, same thing.
Here in this case, I was directed for granted anticipatory bail while the FIR was.
एथिरे भी अपना order of cognizance को करचंती.
Same thing. And because my
no, you compare the prayers. That is why I had called for same prayer. How is it maintainable?
That's why Lordship, in that case, Lordship granted 15 days time to execute that order.
Yes.
I have filed an IA for
in that case.
In that case.
Yeah.
You want to know what is the order.
That order is there. 991 order filed पर आछि.
973/2024 रे जोटा IA फाइल करथिली सेटा लिबर्टी देथिला आउट फ्रेश. Better application.
991 रे अछि से order टा.
हाँ से 70 ऑर्डर डेट टा मो अपलोड कॉपी टा आउट आईए फाइल करथिल ता पर सेतपे से
permitted to withdraw the CRLMC with liberty to file a better application.
सेतपे मो आउट फाइल करली ए जो जेतु डेट रे फाइल करथिली सेतपे लॉर्डशिप डायरेक्टेड टू फाइल
but
better application prayer.
So that order unless there's a slight mistake, that order ought to have been recorded. Because order was passed, it was disposed of. Thereafter, he files a petition for a withdrawal. I don't know how it was allowed.
Extension
No,
I is also there with me. My prayer.
See, order repeat.
Subsequently, same order.
482 was disposed of. Thereafter, you filed a petition for withdrawal. Recalling that order, this withdrawal was not.
I have filed a modification of the extension of time of that order. Yes, madam. Yes.
This order was wrongly passed. you're permitted to be withdrawn with liberty, wrong order.
Eight kale ଏଥିରେ କରିଦେଲେ ବି ସେଇ ଅର୍ଡର ଆମେ ଯାଇକି ସରେଣ୍ଡର କରି
ସେ ଅଛି ଆପଣଙ୍କ ସୁବିଧା ଅନୁସାରେ କଲେ ହବ କି?
no lords
ଆଜ୍ଞା?
no my lord no my lord
କାରଣ ସେଇଭଳି ଆପଣ ସବମିଶନ କରୁଛନ୍ତି, ଆପଣଙ୍କୁ ଯେମିତି ସୁବିଧା ହବ ଆପଣ ସେମିତି ଗୋଟେ କରିଦଉଛନ୍ତି।
no my lord. And
Let us look at the law, let
Yes,
us
yes.
look at the procedure.
yes
जो 7/3/2024 ର ଯୋଉ ଅର୍ଡରଟା ପାସ୍ ହେଲା to permitting you to withdraw the CRLMC with liberty to file a better application, that was wrongly passed. Because the case was already disposed of. So the question of withdrawal doesn't arise. The question of withdrawal doesn't arise. All right. You do one thing. Considering the submissions, order dated 7/3/2024, passed in CRLMC, মানে সেই CRLMC টা অর্ডার করিব CRLMC রে সেটা তো আমি কল ফর করছে না এইথরে ইজ হিয়ার বাই রেকর্ড ହେଲା সেটা দেখে সে আইএটা কাই 235 না
yes my lord that I petition
the IA is taken up for hearing afresh. আচ্ছা আইএটা আছে আচ্ছা considering the submission, I'll grant him 2 weeks time in that case. Sorla matter. Eta withdraw kar debo.
yes
Considering the submissions. No, in the prothome lekho. It is submitted that the order dated 7/3/2024 was wrongly passed, as the application, as the IA was filed seeking extension of time to surrender before the court below. Then the State Council also fairly submits that the order was passed inadvertently, permitting the petitioner to withdraw the CRLMC with liberty better application, even though the CRLMC had already been disposed of. Stop. Para. Considering these submissions and taking note of the fact that the order dated 7/3/2024 was passed out of inadvertence, same is record. Stop. IA number 235 of 2024 is taken up for hearing afresh. ହେଲା ସେଥିରେ ଆପଣଙ୍କ prayer ହେଲା order dated after considering the submissions and the grounds cited in the IA, grounds cited, the IA is allowed. Order dated 8/5/2023 is modified only to the extent of granting 2 weeks further time to the petitioner to surrender before the court below in terms of the observations made in the said order. That's all. So this order takes care of it. এইটাকে উইথড্র করে দেবো
এটা মোর
এটা উইথড্র করে দেবো
yes my lord the present CRLMC 426
CRLMC 1426 of 2024 permitted to withdraw. Sala?
yes I will get the certified copy of that previous
Yes.
yes
Regularize হয়ে গেল.
okay
Yes.
item 34
Tada. 35.
May I please? Milord, the petitioner is in custody 2/10/2020 and the offense under section 20B, 2C, 25, 28, 29 NDPS Act. Milord, that in the meantime, co-accused, the principal accused has already been released on bail. By the 1481 of 2022, allegation that in a truck, coconut coils along with 28 numbers of bags.
No, the person who has been released on bail is the owner of the truck.
Yes, Milord. He is the driver of the petition truck, Milord. Milord, in custody team 2/10/2020.
No, the owner was not present at the spot. That is why he was granted bail. But you were present at the spot.
2 persons are present at the spot, Milord.
Who is the other person?
Who is the other person? That has not been in the prosecution case, Milord.
कौन है इसे देखें?
2 persons.
You have the case diary?
Yes, first time I showed it.
Interim
Guru
bail.
earlier rejected
This
it.
is interim bail. Lord. Interim bail.
8381/2020 7 बार दिया 22 rejected.
And
This man is outside state.
co-accused also outside. Both are Andhra Pradesh.
So you obtain the case diary. Case diary भी obtain लेते पूरा तो फाइनली सुन दो कहीं भी करे interim bail. Case diary भी obtain list this matter. What a week पर करो.
Date may be fixed.
20th August.
कुड़ी. बोले 20th August.
Council पर NCB.
मैं लिखा इस तो ना था sure ना.
Item 36.
I'm seeking a passover.
All right. Pass over.
Item 37.
Sir,
Yes.
the petition custody since 27/7/2021 matter. And earlier on 6/1/6/7/23, on the ground of illness of his wife, your lordship was pleased to, while disposing the bail application, he was granted 2 months interim bail. And on completion of 2 months, he surrendered in time. And your lordship see that in the instant case involved one bolero pickup.
Already considered or and rejected on merit or कौन करा जाए? Merit तो करा जाए कौन करा? I think I have granted you interim bail, not that I have not granted you. Where is that IA? You have not filed in IA. File in IA, will consider.
Let's keep it to day after.
Yeah, day after, next week as well. This is matter next week as per.
Except the petition, all of the courts already granted bail.
They were not apprehended from the start.
Yes.
Spot.
In fact,
one is escorting and
the bolero driver and 2 persons rode on the vehicle.
Yes.
And the
Yes.
pillion rider, all of the managed to clear up.
All of it. Yes, item 38.
Let's keep it next week.
Next.
May I please your lordship? Extension of time, my lord.
First time it has come?
My lord.
6 months just passed away.
All right, 2 weeks time. Yes, I will call it over. Sorry.
item 39.
May I please? 363 and 365 of IPC. Present petitioner is the principal accused and he already married in victim. My lord, annexure 2.
He is the principal accused.
Principal accused. He is claiming that he has married, but he is not producing the victim girl for recording of the statement. Last 2-3 occasions, your lordship was directed. Not directed, not by way of order, my lord.
Obtained a 164 statement.
Where is it? 164 recorded?
Produce कॉलेज से ना होगा?
हमें प्रोड्यूस करिया ये अच्छो हम कोर्ट कहले
हाँ इन
कोर्ट कहीं कोई
कहीं कोई भी
कोर्ट कहीं
मर्डर तो अच्छी है वो
I grant you interim order.
अच्छी इंट्री मर्डर अच्छी
Interim order अच्छी. All right.
yes madam they are not producing
The state council is directed to produce the parties are directed to produce the statement of the victim recorded under section 164 of CRPC. List this matter.
27th August.
27th August. Interim order to continue.
Item 40. On behalf of TK Ratha, passover.
Passover.
Item 41.
Please, your lordship. Petitioner, is implicated. Contraband ganja was seized from the house of one Ghanashyam Jaina. During investigation, it comes to light that the petitioner had there is some bank transaction with the main accused. Subsequently, the petitioner, another accused who has been granted bail by similar footing, he has been both are charge sheeted on the ground that this petitioner and so many other persons, they have bank transaction with the main accused. Ghoru baharla ganja, contraband ganja. He had no action, either he was present or nothing. I'm stand similar footing person was annexure 3 who has been granted bail and suitable. So there is no other material except the material that they have. Not only these 2 persons, other persons of there is bank transaction with the main accused well. That is the only material against me.
Yes.
That is their method. And one mobile phone has been seized from that main accused. There are some WhatsApp chat, Gonjero photograph and other things has been sent to him. And the bank transaction are there with the main accused.
Mr. Naikoro, Passover Tanija. What item? What is your matter?
36, my lord.
36, yes.
Yes, under section 302 by 34 IPC, my lord.
Yes. You have the case diary?
Before calling the case diary, my lord, there is no change in circumstance. Your lordship see order dated 6/11/23 passed in 11,428 by 20.
In that case, let me.
Paragraph 5, your
In
lordship.
that case, let me have good video.
Your lordship see paragraph 5 of that order which has been rejected.
My lord, on merit, I don't want to press, my lord. This is a case, my lord, where there is a quarrel while a procession, my lord, by processions was going on. There was a tent, my lord, previously constructed by another man, my lord. There was some damage, a quarrel ensued. Thereafter, they got hold of him, they called him, got hold of him, and it's my lord assaulted, as a result of which died. Admittedly, this petition is the principal accused, my lord, others have been granted bail. Your lordship has rejected my applications. My friend has rightly stated that there is no change of circumstances. I pray, my lord.
Day after tomorrow. Maybe if you can file it in course of the day, and if it can be taxed, so day after tomorrow, better. Tomorrow, if you want.
Next day after tomorrow, next week.
What? This is matter next week as Learned Counsel for the petitioner wants to file an IA. Yes. I'll keep it pending and then I will. Mulu rakhu. Bail good dena rakhi se state council.
34.
Bail lo joda aram to. Bail lo joda chi se oda khale.
32, my lord, not press, my lord.
Item 32 not press. Item 34.
34, my lord, custody my lord, 23/1/22. Charge yet not framed, my lord. Awaiting for the chemical examination report. And once he is granted the interim bail by lordship and surrender in time.
The petitioner is in custody since
23/1/22.
It is submitted that in connection with such. It is submitted that taking note of the non-submission of the chemical examination report in the court below, this court had granted the petitioner interim bail for 3 months as per order passed in BLAPL number 9725 of 2022. The petitioner surrendered in time without misusing his liberty. It is further submitted that even after more than a year, even though more than a year has elapsed since then, the chemical examination report has still not been filed. As a result of which, charge has not been framed. Stop. Since the petitioner has already been in custody for nearly
More than 2.5 years.
More than 2.5 years, and trial is yet to commence, I am inclined to take a lenient view. Let the petitioner be released on bail on such terms and conditions, so and so, so and so. Each day appearance before the court below. Yes.
Regular bill.
Regular.
Man.
Yakov? Avnai?
Item number 40. Only have a decade, my lord. Extension of time. Surrender.
First time it has come.
Instruction.
No instruction को लेकिन जो वो कोर्ट है वो मोर instruction नहीं. Correct. 2 weeks further time is allowed to the petitioner to surrender. Avnai? Obliged. Question number. Yes, Mr. Raut.
This was posted for yesterday, my lord. Due to non-appearance of the opposite party, this was.
Anybody appearing today?
No, my lord.
Similar Kardab. See you further. See Vrindavan Raut, Learned Counsel with the petitioner is present. None appears for the opposite party. Stop yesterday also there was no appearance. The transfer application is taken up for hearing. Allow for
Interim order maybe yesterday.
No transfer application for allow for
I am not.
Item 10 was passed.
24, I have some difficulties after launch.
What plans? So what difficulty do you have after lunch?
Another
court. Yes, who's there? for the petitioner?
I am for the opposite party. Interim order is there, madam. So your lordship have done the matter.
All right. None appears for the petitioner. Then counsel for the opposite party is present. Raise this matter next week, interim order to continue. Okay, all right.
Item 10 was passed though. It's a matter of lordship where the petitioner is a old lady. She's suffering since long. And the issue is that lordship, her daughter, date of joining into the service has been aired by the department. That is in place of 80, they have mentioned 88. That is the whole issue. For that reason, annexure 5 and 10 are before lordship, which is impugned before lordship. 10 is that order passed by the joint director, basing upon the direction of the Honorable Court in a writ application filed by the petitioner. There, what he opined that annexure 9 is the order where the direction is given by Honorable Court. Last portion, page 20 for my read. This being the position, we direct the Director Higher Education, Appeal Part Note 2 to look into the matter and take a decision. Again. Then annexure 10 again. Here, while the authority was the opinion that the prayer of the petitioner cannot be adhered, is because there are not sufficient materials available with him.
To revise the date of joining.
Again, the issue on that score, let's see, last occasion notice issued.
The settled position of law, it is very difficult to revise the date of birth once it has been entered.
Not date of birth, it is date of joining. That is the issue. 80 जगह 88 है. Some records are admitting that she has joined during 80 after death of her husband, but some have.
So what is the finding?
Finding again. Finding that page 26, let's kindly see. Para 4 is the relevance one. There they says that her pay be refixed by director has discretion under different OSRP rules. A be calculated. See the coach in the three.
It is a purely factual issue.
So
what are the materials?
The college administration have already entered appearance in this case. They have also filed their counter, and in the counter, as I was pointing out last occasion, that the college administration said that the prayer what are made by the petitioner is genuine, that is based on records.
Okay.
Now the my friend is appearing for the concerned college management.
Yes.
So that is there, and now the government.
So you accept that she had joined in 1980?
Yes.
As per the records. So what are those records? Yeah, what records?
Record, inadvertently, it was reflected as 1 to 88.
Where is that record?
Recently, the principal has.
Why don't you come to this side? Why don't you come to this side?
Yes.
The appointment number 3, the principal in Mapada College, she has already
submitted all the relevant records to the deputy director. The letter dated 31 to 2024 is explanatory. The contents vividly describe that whatever she has reflected in the writ petition are mirror a ring of truth, and now no suppression of material facts, no misrepresentation, and she has suffered.
When is the date of joining? Is there any letter of joining?
No letter of joining and appointment are available in the.
So, sir, on what basis is the college accepting her claim to be true? What is the basis?
There are so many documents that
that is what I am asking you. What is the
documents no, sir, I have not produced. I have only because the onus is upon them to establish. Once they file documents on their behalf, then it would tantamount to collusion.
No, if something is based on records, then what is the matter of collusion? It cannot be told that way. Anyways,
collusion between whom? Between petitioner and the appointment number 3. That she is supporting your claim.
It's not a question of supporting. It's not a question of private.
Based on records, man.
Absolutely based on records. So where is that record? I would like to see one record which will be acceptable by all.
And all the records have been forwarded to the deputy secretary by the principal. Meanwhile.
Document को आपको पकड़े कॉलेज में सब पढ़ेला.
सब कॉलेज सब.
मतलब document तो copy थी वो ना. Copy forward तो original document नहीं थी वो.
Yes, copy the number
to be. Yes. Mr. Das, what is your?
Sir, now the difficulty is neither do I have filed any counter affidavit from the side of the state, nor any instructions have been received. Now it is a matter of 2007.
Yes.
Since your lordship wants to look to the record on the basis of which this Annex 10 was passed.
Yes.
Now this will be, and as had happened in that case where a 2011 document your lordship sought from the directorate. It took so much of time, it has been ultimate trace. Now it is a matter of 2007. So I will make attempts.
No, what I would rather, you see, to cut short the argument,
sir.
She claims to have joined on a particular date, which is disputed by the director. Now, you may be having some documents.
That is what I'm. Annexure 1.
Annexure 1.
Page 13. Running page 13. Annexure 1. It is a letter from the secretary of Neopada College to the director, public instruction. There, what he says, approval of the appointment of command Srimati Guredi, the petitioner, widow of Siddheswar Mukhi, ex-sweeper. There, the letter says that this office letter number so-and-so dated 2nd March 80. Sir, with reference to this office letter number quoted above, I am to inform you that Srimati Guredi is working as sweepers since 1/2/1980. After the death of her husband on 22/1/80 due to road accident. As her appointment has not been approved.
This appointment at this distance of time, one would not like to go into the legality of such appointment because you come to Annexure 2. In view of the hardship caused to Srimati Guredi, wife of so-and-so, the management out of sympathy has appointed her as sweeper against the vacancy of late Mukhi. So almost like a rehabilitation appointment, isn't it?
Undoubted.
They have of course said with effect.
That date I've seen. 1/2/2008. That 1/2/1980.
88.
So this should clinch the issue.
Yes, surprise the issue also. And the next letter also, Annexure 3 is also there. There, lordship will kindly see that is also
for approval.
Lordship. There also with effect from the date of the incumbent. That should be termed as
the post was approved.
1980. Yes, sir.
Then in exercise of power conference, appointment of Sri is hereby approved. So approval also from that date.
1/2/1980.
All right.
That is also the case of the petitioner also.
If you want to take instruction further, then
it can be disposed.
That difficulty may be there as had happened.
No, but what happened? What was the cause of action for coming to the court on the last occasion?
Last occasion is because the authorities have not taken active steps for declaration of the dead. We approached this court under.
Why the approval? Your approval order says 1/2/1980. So then what happened?
Annexure 9, lordship, the writ application copy is attached. They, the lordship will see that this was the prayer.
Again. Annexure 5 is also 1/2/1980. 1988. Oh, this is where the mistake arose.
That is the mistake.
So what did you do?
Then we approached the concerned authority.
for through principal also, principal returns many
All right, then-
letters.
His approval order of the director is there. That must be available with you. Annexure 2, the original copy must be there with the in the.
Must have been.
Yes, that is the only thing that you have to find out. If you find out from the director's office that the post was approved with effect from 1 to 1980, end of the matter. Nothing further remains to be decided.
And the date as has been given in this letter
All right.
was on the basis of records.
All right, heard in part, in course of hearing, Sri Mahapatra and counsel for the petitioner draws attention of the court to order dated 9/9/1980, whereby 9/9/1980 of the then director of public instruction Odisha, whereby the appointment of the petitioner was approved with effect from 1 to 1980. Subsequently, the order dated 24/1993 said date was modified to 1 to 1988. Learned State Council shall try to obtain the original letter dated 9/9/1980 of the then director. For perusal
By the deputy director, from the directorate, your lordship.
for the director, yes, of the director. No, this was issued now. The original order you see by the director of public instruction. The memo has been issued by the deputy director. Oh, that's natural. Memo has been issued by the deputy director.
This annexure 2 is entirely of the.
Annexure 4. I am talking of annexure 4.
Annexure 4, sir. Page 7.
Annexure 2 is prior to annexure 4.
So
annexure 4 is irrelevant. All right, list this matter on
3rd September.
3rd September. Yes.
Yes, get to this. Sir, item number 20.
20, nahi?
okay.
None appears disposed of.
My lord,
Yes.
I mean, my lord. If
Yes.
my lord wanted to know the status of the case, my lord.
Yes, what has happened?
I have not received the instruction. I pray 1 week time. On the last occasion also, I prayed, I communicated to the
All right. As requested by Sri Asajal and counsel for the petitioner, is this matter next week? It is made clear that no further time shall be granted.
My lord, my lord.
Capre?
So I don't know 23.
23? None appears, it's this matter 1 week after.
I don't know 24.
Let's see the Passover. He is on
No, our password.
legs in another.
Kichi dakar.
Malad, they had asked me to accommodate.
No, accommodation is to be done by the court, not by you.
Yes, Malad.
Unfortunately.
He had just asked me to. Malad, will proceed with
Let's see
the.
tomorrow. And taken up tomorrow.
This matter has been called out thrice. On the previous 2 occasions, Mr. Tripathi was here. Now he is vanished.
Morning.
Yeah?
Morning. Tomorrow, let's.
All right, tomorrow, as straightforward.
I don't know 31.
Well, this is the matter which relates to the incarceration of the petitioner for us almost a sum of 80 and 9 months, my lords. For a period of 80 and 9 months. And my lords, but till date, my lords, final charge sheet has not been given. He is languishing behind bars. Nothing is happening, my lords. And it's 80 and 9 months, my lords.
What affidavit has been filed by the.
Your lordships had also called for a report from the, I think, the CBI judge.
I don't think so. There's no such case. Ashi.
Your lordship said
Yes.
your lordship said initially called for the report At that point of time, your lordships, the report suggested that the delay was not attributable to the prosecution. After that, they had filed an IA, your lordships.
What was not amenable to prosecution?
The delay was not attributable to the prosecution. He has given
Delay
some
was not
reasoning.
attributable.
Lordships, after that, he has filed an IA because initially the main bail application was argued for some time.
Yes.
The grounds taken in the IA, your lordships, is not delay in the trial. Some other grounds have been taken, your lordships. To which your lordships have filed a reply.
You have filed a reply?
Yes.
Where is that
9th,
reply?
9th May 2024, I had filed the reply.
Is it styled as an affidavit in opposition?
Yes, your lordships. Yes,
All right. It's a long reply, much longer than the IA.
Yes, your lordships. Paragraph 15, your lordships,
Yes.
I have answered, but the IA, your lordship, doesn't speak about the delay in the trial, your lordship. The IA speaks about some illness.
My lords, that is self-evident. Do I have to state all these facts in the IA, my lords? Delay in the trial is very much evident before your lordship.
Anyway, he's asking for interim bail.
Yes,
I've answered it, your lordship. Your lordship may kindly come to paragraph 15.
Yes.
This interim bail, your lordships, is stating that the son is suffering from asthma in 2023, which was 1.5 years back, your lordships.
Yes.
I have answered that, your lordships. He is getting good treatment from Amitabh Pahari, lordships, who is the renowned doctor of state of Bengal, and is a highly qualified and eminent, your lordships, and 1.5 years is getting adequate treatment, your lordships. And he's saying that it's life-threatening, your lordships. This IA was filed, your lordships, 100 days back. The son is getting adequate treatment, and the prescription, your lordships, are of the year 2023.
Yes, 100 days back, Mr. Naik, that is true. But the fact that it has not been taken up for 100 days thereafter, maybe the fault of this court. But
no, not your lordship's fault. He was taking time, your lordships.
No, only once he has taken time. Only once. You have also taken time, he has taken time. Last time you had taken time. Less than 2024 as played for by the Land Council for opposite party. The previous was... Yes.
Your lordships, the prescription.
It is there in the order sheet.
Yes, your lordships.
It is there in the order sheet. On last occasion, you had taken time anyway.
Yes.
That is besides the issue.
Secondly, your lordships, as far as the admission of the second son is concerned, your lordship, this is the last academic year, your lordships. So 3 years, he has already paid the course fee. If you would not have paid, you would not have continued with the studies, your lordships. So virtually there is no ground, your lordships. And for
There are two things. There are two things. First is the incarceration is for 8 years and 6 months. Second
9
is
months. 9 months.
9 months rather.
Yes.
I was looking at your ISO.
10.
Second is
More than
whatever ground he has taken is, of course, that will be considered. But the other fact remains that trial has not even started. So it's not likely that the trial will be concluded in the near future. And all that he is asking is for interim bail. Interim bail on stringent conditions can be given, like, surrendering of passport and maybe some cash security also.
But now, the further investigation is going on. 25 crores more money has been attributed to him, and it was found that he is the director of 2 other companies, your lordships. So investigation qua him, your lordships, is still continuing as far as further investigation is concerned. And all the co-accused, your lordships, are still in custody.
I understand, but 8 years investigation is going on for 8 years, Mr. Naik. 8 years, not the 8 years. A man's liberty. What will happen? Supposing what will happen if he is acquitted ultimately? That question we are always confronted with. Even recently we had a conference with many Supreme Court judges had also come. The judiciary is unable to answer that question.
Yes.
Nobody can.
That is exactly why, if your lordships remember, I haven't got the judgment. Sanjay Chandra, starting from Sanjay Chandra to Chidambaram, my lords, they say pre-trial incarceration is not contemplated.
No, but what he's saying is his apprehension, I can understand as a CBI counsel, is because of the magnitude of the offense, the huge amount of money that is involved.
My lords, true.
And it is not like another. It's not just like a murder case that it will be investigated very soon.
No, I'm not on that, my lords. After 10 years, again, when I move for bail, again he will say another 25 crores is pending against him. I am going to trace it out. This will go on forever and ever. My lords, there has to be an end. 8 years, 9 months means I have suffered the incarceration for almost all the sections.
All right. I'll pass order. I have your affidavit in opposition.
But your lordship, two things I would like to point out.
Yes.
Then your lordship pass any order. Your lordship may kindly come to paragraph 9. Your lordship
paragraph 9 of what?
Of your lordship's order, which is a reported judgment 1245 of 2022, your lordships. Which your lordships, when dismissed it, judgments I'll cite, then your lordship may pass.
Yes.
As regards to the arguments, there is inordinate delay in the completion of investigation. It is to be noted that huge network was built by companies all over the country, including several stakeholders and institutions. Hence, the inability of the CBI to submit final charge sheet is understandable and cannot ensure to the benefit of the accused petitioner.
Anywhere to the benefit. Yes.
Yes, this is your lordship's observation, and the position remains the same today. Furthermore, your lordships, two Supreme Court judgments, your lordships, I have cited. I have given the copies, your lordships.
Okay.
Compilation of judgments, last two judgments, your lordships.
I don't think I have.
I've given you
Mr. Naik, I don't think I have those judgments.
I'll give another. I'll give one more time.
Yes, what is the ratio? Just tell me what is the ratio.
Your lordship, the ratio, I would like to read that. If there is necessity for further investigation, the same can certainly be done as prescribed by law. The mere fact that there may be further delay in conclusion of the trial should not stand in the way of further investigation. If that would help the court in arriving the truth and do real and substantial as well as effective justice. Lordship of hearing, my learned senior also argued about Article 21. This judgment further discusses in paragraph 83, a speedy trial is the essence of fundamental right under Article 21 of the Constitution of India. But in comparison with the concept of fair trial, both being inalienable constituents of an adjudicative process to culminate in a judicial decision by the court of law, there is indeed a qualitative difference between right of speedy trial and right of fair trial, so much as the denial of the formal by itself would not be prejudicial to the accused. So, lordship, when a difference has to be made between a right of a speedy trial, Article 21, and a fair trial, and investigation is pending, fair trial will supersede your lordships.
All Mr. Naik is correct and valid, but in respect of a regular bail application, we are on an interim application, and he has, of course, taken the ground of
And your lordship's apprehension, your lordships, paragraph 11, I'll finish it up, your lordship, I'll not waste further time.
You can take your time. I am in no hurry.
As already discussed, the allegations labeled against the petitioners are very serious in nature. Large number of depositors have been duped and hard-earned money and amount so swindled is huge. Considering the status and position of the petitioner, the possibility of tampering with the evidence and influencing the poor director, influencing the depositors cannot be ruled out entirely. So the position remains the same here. If 2 years the trial could not proceed, he is going to do your lordships. And at that point of time also, your lordships would have given him bail with stringent conditions. Your lordships felt that it could not have been done. And your lordships had clearly written that considering the status and position of the petitioner, the possibility of tampering with the evidence or influencing the poor cannot be ruled out. 9,000 crores, your lordships, is pending. And these all depositors are small times, your lordships, rickshaw pullers, class 4 employees, and some of the members of your lordships, the street fund companies. Out of now 9,000 crores, easily, your lordships, you can buy and tamper with the evidences, your lordships.
All right, I'll pass order. Okay. If I decide to grant bail, first of all, I will not grant interim bail.
Yes.
We are talking of interim bail, not regular bail. Bail application will be kept pending.
Malo.
If I decide, I don't know, I may reject your IA also.
Malo.
If at all I decide to grant you interim bail, it will not be for 6 months. It will be for less than 6 months. Much less.
Malo.
Number one. Number two, it will be on very stringent conditions,
Malo.
including imposition of some cash security.
Malo. I'll see.
And the bail application will be kept pending.
Malo.
Stringent conditions, as in, you'll have to deposit the passport.
Yes.
And all other things. Maybe appear before the IO and all such things. If at all, let me know. Let me first.
I'm just asking your lordships to see whatever my friend is submitting, my lords. It's all in, my lords, in respect of a regular bail. Supreme Court even goes so far as to say that the prohibition under the NDPS Act is thrown out when there is a delay.
Here every day, routinely, we are granting bail in NDPS case. Today, probably, Mr. Mishra, more than 200 kgs or something. But that man was in custody for more than 2.5 years. I granted bail. Simple as that.
My lords, what I am saying is a person, your lordships will take into consideration the fact that a person is already behind bars for 8 years, 10 months.
True. But this is a peculiar case. Where large number of small time depositors are involved. As he has very rightly pointed out. And you see, I am not even looking at the total quantity. For a moment, let us keep it aside. Sheer number of persons who are involved.
Sheer number of persons, my lords, but then, my lords, he has suffered the entire period of incarceration prescribed under the statutes.
No, your lordship.
Except 409. 409, my lords, is strictly not attracted. That's a different.
Argument, your
for us-
lordships, if your lordships will remember, that argument was rejected in lordship's order.
No. That argument was never rejected. The argument was
He said he had
that
argued
he
in
has
that point of time.
completed 50% of
You wanted 436A,
436A. That argument was
which I did
rejected
not
by your
accept.
lordship.
Which I did not accept.
Yes.
Anyway,
Sir was-
so let us see the court, the job of the court is to balance both sides. Let us see. I don't know what order I will pass. I will have to go through each and every. All right.
Lordship, I'll file those list of judgments again if your lordship it has been missed.
No, it is not there in the record. You may associate to just give a copy of the citations at least. Citations are the paragraph that you are relying upon. It will be easier. You don't have to file those judgments. Copies of the judgments need not be filed. Yes.
Oblige.
Hearing concluded or reserved? I hear it. Yes.
Oblige.
Yes, next one.
Paragraph 15 in the IA, I have given the reasoning. Sir.
Yes, correct. You just point it out. Bullet point, you point it out in your memo, that will be sufficient.
Yes, lordships.
Sorry, weekly list. Yes.
Weekly list item number 26.
Yes, item 26.
ତାଲିକାର ଗୋଟେ ଥିଲା 500 ହେଇକିରି item 19 item 19
Lakiti.
weekly ର
हाँ से week.
item 9.
Lakiti. Item 19.
Item number 19.
May I please, Lordship? Lordship, in this case, I am the respondent and plaintiff in the court below, Lordship. The suit is for the right title.
You got defect as per SR not?
Yes, Lordship. Defect is for the exemption of the court fees, Lordship.
Exemption of court. Yesterday, I was asking you.
Yes,
You could not answer the question. Today, I am sure you are prepared. Yes, very good. कौन से कौन दूना तो कौन से आइए आज फाइल कर
exemption of court fee.
Were you exempted in the court below?
No.
You are the first appellant.
Yes, sir.
You had filed the first appeal.
No, this is second.
Our court की first appeal की
Yes, I am.
You had filed. You were exempted.
That is, Lordship, that appellate decree is not with me. And today, I telephoned that advocate, but he didn't pick, Lordship. But I have that appeal. Second appeal file ହେଲା 22 ମସିହାରେ ସେତେବେଳେ ସିନା ସେଟା ପସନ୍ଦ ଏକାଠି
डिक्री କାଇଁ डिक्री फाइल
ନାହିଁ ମୋ ପାଖରେ
डिक्री नहीं केमତି हबो
it just, Lordship, just may I place it. This is the appeal which I have filed before.
Order 21, what does it say? Order 21, I don't know, you tell me. You are practicing in the civil side, you may be able to tell me. Degree file হওয়া দরকার না দরকার নেই তাহলে এসআর হেই না তো
এটি payable লেখা আছে but I
300 টাকা payable.
That is the appellant for the purpose of jurisdiction and payment of.
Is it a partition suit?
Yes, sir. No, Lordship, this is not partition. Right title, interest and permanent.
300 rupees किमती এত কম কিনতে হলো payable not paid. Why are you claiming exemption on what ground?
That is the my income is less than 1 lakh.
Income certificate?
Deychi, Lordship.
So this must have been filed before the court below. You are Siddhar Raut.
Yes, Lordship.
Huh?
Yes, Lordship. Siddhar Raut.
Appeal is of 2022. At that time,
ସେଇଥିପାଇଁ ମୁଁ ଦେଖିବାକୁ ଚାହୁଁଛି ତାଙ୍କର ସେଇ ଫାର୍ଷ୍ଟ ଆପେଲେଟ୍ କୋର୍ଟରେ କଣ ହେଇଥିଲା
ସେଇଟା, Lordship, ଲେଖା ହେଇଛି the same as the value of the suit against which the appeal arises and court fees owed 534 is payable as per schedule A.
କୋର୍ଟ ଲେଖା ହେଇଛି କୋର୍ଟ ପଢୁଛନ୍ତି
memorandum of appeal.
appeal memo.
ମୋ ପାଖରେ ନାହିଁ, Lordship.
how it will register it, will keep it. You find out. You had filed the first appeal.
Yes, Lordship.
Isn't it?
Yes.
So you have not suddenly become poor. You must have also claimed exemption in the court below.
Yes.
Otherwise, how would your appeal have been admitted? Your appeal was admitted by either by payment of court fees or by exemption. You are claiming exemption. So it must be reflected in the decree.
Yes, sir. Kindly grant some time. I will.
Yes. You take it back. You first know what are the facts, then file an IA. File as requested by learned counsel for the you the appellant.
Yes, sir.
The appellant. Is this matter 2 weeks for a date for 2nd September.
2nd September.
Defect be removed in the meantime. I am passing this order. You file an IA. We will consider.
Item 4 in the part hat list. It was passover for okay.
If some admission matters, then we will take it up. Amar kitna admission achi? This will take time. This has been, Mr. Tripathi, this has been adjourned on the prayer made by somebody on your behalf, at least twice or thrice.
Twice, my lord. Last over for twice.
Kitna achi?
Only I have to give it.
12 achi. Item sardo. Item 4 will finish it. Yes, item 4. Kaun each matter?
I am for the respondent and the appellant. I am for the
Appellant. Kaun matter kaun?
matter is that, my lord, the present the plaintiff was the appellant before the learned lower court. And here he is the respondent. It is against the reversing judgment. I have prepared a short note, my lord.
What is the substantial question of law?
Substantial question of law is framed that when he is claiming adverse possession and also disputing the title, my lord, whether both can go together or not, my lord. Now, please see that.
Have you given a copy?
No.
Copy. Originally, the suit land was recorded in the name of Dhanu and Kala. That was 10,000 square foot of land. They sold to Brajavasi Bedbak 6,000 square foot and 4,000 square foot to Mitradev Nanda. And Mitradev Nanda is not material. And out of this 6,000 square foot land, Brajavasi Bedbak sold 4,000 square foot to Dibakar Mishra. And Dibakar Mishra, LR Mane, Somonath, Vishwanath and Manoranjan, they sold that land to Rabindra Bag, that is the plaintiff, Miller. Now here
for a moment, you are the plaintiff or the defendant?
I was the plaintiff.
You are the plaintiff. So you are Rabindra Bag.
Miller, there are two Rabindra. Here the defendant side also Rabindra and the plaintiff side also Rabindra. And towards the left hand portion, let's see, Harihar Das purchased some land from Brajavasi Bedbak 6,000 ରୁ 4,000
some land माने कितने 6,000 ये तो 4,000 गला 2,000 स्क्वायर फुट वाला
आगे 2,000 से किनिले
से 2,000 किले क्लियर
आगे
ओके
एंड हरिहर दास एवं तार पिला माने रामचंद्र दास ए माने एग्जिबिट 33 34 और 35 रे से लैंड बिक्री कले डिफेंडेंट रो मदर को नाउ लॉर्डशिप विल फाइंड दैट टुवर्ड्स द बॉटम मिलर I derive my title under exhibit 6 that the 214 plot number 289 area 89 decimal that is under exhibit 6 that is my cell deed. Now their cell deed
that according to you is 4,000 square feet
4,000 square feet. Their cell deed Miller khata number 59 plot number 2558 and 2155 area 209 decimal. Both are different. Now what happens, my lord? The plaintiff after purchasing this land, he filed the suit for confirmation of possession for permanent injunction, and cause of action was that his vendor Dibakar Mishra, when sold the land, ROR settlement ROR was published in his name, in the name of Dibakar Mishra. In the settlement ROR, the description of the land is given as Basogruha. That means before purchasing that land, Basogruha was constructed by Dibakar Mishra over that land. And Dibakar Mishra rented this land, that Basogruha, to the mother, to the defendant number, to the defendant.
But in the sale deed, it is referred to as Meladiho.
Meladiho, Miller. But in the sale deed, it is referred to be
sale deed ru ROR bhitere hela 4 mas.
Nahi. Dibakar Mishra vendor ro bapankar naare jetebele heithila khatianta settlement re setila thila basogruha
okay
tar pila mane jetebele bikri kole mate setre reside hoche Meladiho vacant land. My lord, here my lord, what happened, the plea of the defendant is that adverse possession. Now I am reading the written statement, my lord. Let's see which getting.
Yes.
Written statement of paragraph 5 first. However,
Paragraph 5. However, in the current settlement.
okay, in the current settlement, the suit land has been recorded in the name of Dibakar Mishra in holding number 214 Moujas Soleipali, PS Bolangir, District Bolangir. Thereafter, Miller, in page 2 of the page 29. Thereafter, at page 4 of the written statement, towards the middle, the mother of the defendant number 1 constructed her residential house by encroaching upon an area of about 1625 square feet, denying the title of Dibakar Mishra, and with the knowledge of him and his sons in the year 1978, and since then she was in exclusive possession of the same on her own right, title and interest. She has also connected electricity. Here he is denying the title of Dibakar Mishra. Here next page, Millard, next page 5. 5 towards the middle porch. Therefore, the defendant number 1 and 2 had perfect over the lands out of Schedule A land, which are in their respective possession, and as such by remaining possession over the portion of the suit land peacefully, continuously, with an animosity with the knowledge of the true owner Dibakar Mishra, and all his sons thereby perfected their title over the suit land by way of adverse possession in the, and the defendants are absolute owner of the same. In one place, they are denying the title of Dibakar Mishra, and in the another place, Miller, they are claiming adverse possession. Now the fact remains whether the defendant has perfected his title basing upon the adverse possession. Now, Lordship, kindly turn to the judgment of the appellate court. The learned appellate court has discussed. The learned trial court has given 13 findings, Miller. Lordship, kindly turn to page 4 of learned appellate court judgment.
Yes.
Paragraph 4, page 6, paragraph 4, Miller. The trial court taking up issue number 2, 3 and 4 together under one heading in the light of rival contentions examined whether the plaintiff was able to prove his title in respect of the suit property and act to the trial court. As per the evidence, the alleged sale of suit land in favor of plaintiff was not coupled with the delivery of possession. That is the first finding. Second, according to trial court, the evidence adduced by plaintiff did not show that he was financially sound so as to afford to purchase the land for 68,000, for which further finding 3, according to trial court, the sale deed appeared to be a nominal paper. 4, further observed by the trial court that the impugned sale deed did not bear any recital about existence of any residential house over the suit land, though the ROR in respect of the suit land on 8 shows that there was a house over the suit land. That is Exhibit 7. In the circumstance, it was held by the court below that the stand taken by the defendant that they constructed house over the suit land was believable. It was therefore found by the trial court that the stand taken by the plaintiff that he inducted the defendants to the house over the suit land for a monthly rent of ₹500 after purchasing was fallacious. On the other hand, from the evidence of the defendants, it was found by the trial court that their evidence as to construction of the house, taking electricity and water supply to the house, established that the suit land was in continuous possession of the tenant. My lord, here the other issues are not relevant. Let's kindly turn to the finding of the learned appellate court on this adverse possession, that is at page starting from page 15 of the appellate court judgment towards the bottom.
Yes.
15 page. In appeal, High Court
That is about that case which was cited.
Again, page 16 ne achi. Otherwise, page 16 ne towards the middle. Otherwise,
yes,
mere possession of any number of years cannot constitute adverse possession. Regard must be had to the animus of the person doing the act, and this has to be ascertained from the fact and circumstances of each case. If the possession of a person referable to the lawful title, same cannot be adverse if a person enters the possession with permission of the true owner. Here, Miller. Here towards the bottom, Miller, the finding is given, but there is no specific evidence in this regard. Rather, on the other hand, the current settlement ROR Exhibit 7, the suit land has been found to have been recorded in the name of Dibakara Mishra with house over it. Assuming for the sake of argument, even if the claim of defendant is accepted as true, yet as they say that they acquired the land, finding it vacant at the time of purchase of adjoining land by them and constructed the house thereafter, then it must have come to the notice of the persons of the locality, but not a single person of the locality has been examined. The defendant although say that they, after making construction of the enclosed land, continuously possess the same, ignoring the title owner, yet did not take any step for mutation case number so and so, in which the holding number allotted to them in respect of the suit land. Thereafter, Miller, the boundary at page 17 towards the middle.
Yes.
The boundary of the land under possession given by DW1 2 also differs. DW2 in para 2, para 8 claims to have been seen Dibakara in the year 1980 to 83, but he cannot say any specific date or the occasion of the suit land. Further, an important aspect, whether the defendants before encroaching the suit land knew that the suit land belonged to Dibakara, is absent in the pleading. And thereafter, Miller, the proof of adverse possession. So far, the proof of adverse possession is concerned, this defendant number 1 and 2, they have adduced any evidence. They could not say in their deposition on which date it was they came over the possession, when the house was constructed by their mother, and all these ingredients which need to be proved to prove adverse possession are absent in the evidence, Miller. And now the Law and Trial Court has committed error in this case by putting the burden of proof of adverse possession on the shoulder of plaintiff. The Law and Trial Court has observed that plaintiff has to prove that defendant was not in adverse possession. Here, Miller, I have prepared a note, Miller, already served a copy to my learned friend.
Already there's a note.
Yes, my lord.
Is it the same note?
Same note, my lord.
Then it is already there.
It's already.
Now
I am placing the note, relevant part of my note, my lord.
Don't place the date chart, only place the.
I can only place the part of the note. Now, Miller, page 11 of my note. From the aforesaid findings.
Please. Well, continue.
From the aforesaid findings, the sole question has to be decided whether the appellants have perfected their right by way of adverse possession with respect to the suit land. Before making submission, The admitted facts as per the pleading and oral evidence, documentary evidence are given below. I'm skipping that, Miller. That is only the exhibit 6 and exhibit 33, 34 at appearing Roman 4 to Roman 6 are relevant. My lord, I'm skipping it. Thereafter, on my submission, my lord, submission number 1, that is on adverse possession. On a bare perusal of facts, it is clear that the defendants have claimed their adverse possession over the suit land. The well-settled principle of law is that a party claiming adverse possession must prove that its possession is that maxim. The possession must be
maxim has been wrongly written.
Yes,
Neck NEC.
Again,
NEE.
So it like
Neck V, neck calm, neck precarious.
again. The
Peaceful,
possession,
open and continuous.
again,
The meaning peaceful,
Again,
open.
again. The possession must be adequate in
There are two
content.
things. You may also argue, both of you, corpus possidendi and corpus animus.
Okay.
These are two things.
Okay.
He has to show possession, which goes by the maxim corpus possidendi.
Precedent and animus.
Animus. Animus has to be there. Unless there's animus, mere possession could also be permissive possession.
Yes.
It could be permissive. I may have allowed you to occupy my land, but it will not become adverse.
Okay.
And a possession which is in the beginning permissive cannot turn to adverse. That is the settled position. Anyway, let us begin. Well,
The decisions I have referred to. Thereafter, some evidence, Miller. Page 15. In view of the aforesaid legal position, it is submitted here that in the instant case, the defendants have not pleaded in their written statement either to when they entered into possession, when they started construction and engaging whom and what was their plan for construction. Nothing.
When they entered into possession, when they started construction, this could be relevant. Engage construction.
Evidence. So, pleading evidence. The DW1 at para 9 of his evidence has stated that he cannot say the present plot number on which the house was constructed by his mother, and at paragraph 3 DW1 he has further stated that he cannot say when his mother started construction, and paragraph 10 of the deposition he has stated that he cannot say when constructed her house, mother. In the pleading, the defendants have not stated anything about the suit land belonging to Dibakara. In adverse possession, the knowledge of hostility is also direct, and the same was with the knowledge of the original owner Dibakara or his legal heirs. So, title of Dibakara had definitely not been lost by way of alleged adverse possession. Here, my taking a pause for a moment, Miller. The case of the defendant, the second case of the defendant was that Dibakara was not the title holder, because now let's see that 2-page property detail I have given.
Brajavasi bedback.
Again, ଯେତେବେଳେ ଆଜ୍ଞା ବ୍ରଜବାସୀ ବେଦବାଗ ପାଖରୁ ତାଙ୍କର କହିବା କଥା ହଉଛି ଯେତେବେଳେ ହରିହର ଦାସ ଆଉ ରାମଚନ୍ଦ୍ର ଦାସ ତାର ଆଡପ୍ଟେଡ ସନ୍ ଦ ଲ୍ୟାଣ୍ଡ ଟାକୁ ବିକ୍ରି କରିଦେଲେ ତାଙ୍କୁ ଡିଫେଣ୍ଡାଣ୍ଟ ମାନଙ୍କୁ, ସେଇ ଲ୍ୟାଣ୍ଡ ଟା ଆଜ୍ଞା ପଳେଇଗଲା ଦିବାକରର, ଆଉ କିଛି ସେଠି ରହିଲାନି, ସତ୍ତ୍ୱ ଆଉ ରହିଲାନି। କିନ୍ତୁ exhibit 33, 34 ରେ ଯୋଉ property schedule that is completely different from exhibit 6, that is my cell, ଏବଂ ସେମାନଙ୍କର ଆଉ ଗୋଟେ claim ହଉଛି they purchased some other land that is adjacent to my land and they constructed their house on that adjacent land, ଏବଂ ମୋ ଆଡକୁ ଟିକେ 1600 square foot adjacent land ଖତିଆନ ଗୁଡାକ ମଧ୍ୟ exhibit mark ହେଇଛି without objection ମିଳନ। Now the fact remains, if they are not my adjacent land owner, then how the question of constructing that house encroaching upon 1600 square foot of my land comes. And second thing is, when they are disputing the title of Dibakara Mishra, that Dibakara was not having that title, sellable title, and that's legal heirs are not having title. How they claim this?
Yeah, all these aspects are well taken, but you have to address the court on the apparent discrepancy that they have pointed out with regard to the land being described as Meladiho and a house being admittedly found on the or claimed to have been constructed over the suit land.
Okay.
How do you reconcile to apparently contradictory? What is there? Where is that Meladiho? Yes.
That is exhibit 6.
The trial court judgment at page 16.
No. See document account. Two document is
Exhibit 6.
Exhibit 6.
What does it say?
Please.
Please save me the trouble of going through that document again. You just place that line. If you can read.
I have a second copy.
Yeah, but what do you want again? Yeah, when was it executed? When was this deed executed?
This date was
2002,
Date ta कौन थी?
16th August 2002.
16/8/2002. कौन लिखा है इस पर?
Vikreta Bhatte.
दियंत.
I am reading
I
that.
have underlined it.
बोलना
ଦଉଛି
ता से पढ़ो.
ମୁଁ ପଢି ଦଉଛି ତଫସିଲ sub register so and so thana the relevant is that my lord ସତ୍ୱ 2 ଟଙ୍କା ଜମା ବିକ୍ରି ସତ୍ୱ ଘରବାରି କିସମ ଥିଲେ ହେଁ ମେଲା ଡିହ ଅଟେ.
अच्छा. So it means the land is homestead, but it is a melody.
Melody.
There is
No
no
construction.
of any house.
That is there. My lord.
But in that other document, which is that ROR, this is in
That is
sector
exhibit-
16.
It's six, that
केबे
is.
केबे एटा 16 है.
Exhibit 7
This is
Exhibit 6 टा केबे हिच.
Exhibit 6 to 16/8/2002.
से जो ROR टा है which you are
8.
Exhibit 8.
8.
exhibit 7
Exhibit 7 is Dibakar Mishra.
Dibakar Mishra ROR to
No, sir, Lordship is referring to your ROR.
nahi
That is Exhibit 8.
कौन जो उधर लिखा है जो घर अछि बोली.
exhibit 7 na chega. That is the finding.
ऐसी
That
कौन
is
सी?
Dibakar Mishra's ROR. Your ROR, Lordship is asking.
I just want to know the dates. I want to compare.
Okay.
As you yourself placed that document, Mr. Tripathi, it is very clear. See, पहले घरबारी थिले हैं मेलाडी होट है. तमने इटा उपयुक्त for homestead.
Okay.
But it homestead home nahi.
Melody.
Melody.
ମୁଁ ସେଟାକେ
If
meet
your
kor
Lordship has the Exhibit 8, which is their ROR, I don't have a copy right now. We can determine the date of publication of the ROR. Exhibit 8.
Oh, है. चलो.
ମୁଁ ଆଗେ କହି ଦଉଛି ସେଟା. In 1955 settlement ROR was published in the name of Dibakar Mishra, that is exhibit 7 my lord. In that ROR it is stated the kisam of the land is stated to be Basagruha, exhibit 7 रे plot number 214.
तमने dwelling house.
Dwelling घर बासगृह.
घर बासगृह माने dwelling house है.
Dwelling house. In exhibit 8 what he is saying, what my friend is saying, that is after my purchase, that is my mutation ROR. ସେଥିରେ ଆଜ୍ଞା ଲେଖା ହେଲା ଘର ବାସଗୃହ.
ସେଟା କେବେ ହେଇଛି?
ଆଜ୍ଞା exhibit 8 ଟାର ଡେଟ୍ ହଉଛି 24/2/2002.
That is what they have been pointing out.
ଆଜ୍ଞା
ये 4 मास ଭିତରେ ଆପଣଙ୍କର ଘର କେମିତି ହେଇଗଲା?
ଆଜ୍ଞା.
So either of the document is wrong. Description of either of the document is wrong.
Is wrong.
Now the sale deed says घर बारी होइथिले हैं मेलाडी.
मेलाडी.
କାଇଁ ଲେଖିବାର ଆବଶ୍ୟକତା କିଛି ନଥିଲା.
ସେଇଟାକୁ ବୁଝାଉଛି ଆଜ୍ଞା କହିବି. ତେଣୁ ବର୍ତ୍ତମାନ ଯୋଉ 55 ROR ଟା ଆଜ୍ଞା ହେଇଥିଲା ଦିବାକର ମିଶ୍ର ନାଁରେ ସେଥିରେ ଲେଖା ହେଇଛି ବାସଗୃହ ଘର ଅଛି ବୋଲି, କିନ୍ତୁ ମୋ ସେଲ୍ ଡିଡ୍ ଟା କଲା ବେଳେ ଦିବାକର ମିଶ୍ରର ପିଲାମାନେ ସେମାନେ ତାଙ୍କ ସେଲ୍ ଡିଡ୍ ରେ ଲେଖିଥିଲେ ମେଲାଡିହ ବୋଲି. Now the Somonath Mishra who sold me the land, son of Dibakar Mishra, is the DW3, na PW3. In his deposition, he has stated that house was there, but due to wrong advice, I wrote it.
92 is a bar. 92 is a bar.
Now, my lord,
ଆଉ ତା ଦେହରେ ସାପରେ ଗୋଡ ହେଇପାରିବ କି? ସାପଟେ କରିଦେଲା ପରେ ସାପରେ ଗୋଡ ଫୋଡ ଲଗେଇ ପାରିବ?
actually, my lord, when they challenged my sell deed, they challenged on 2 grounds, my lord. One is consideration money was not given to my vendor, and second, capability of the plaintiff And earning of the plaintiff was not sufficient to meet that consideration.
That's a question of
That was
fact.
only two questions. This point they never raised neither before the trial court nor before the appellate court.
Should they, one more, let my senior complete.
Now the fact remains, Miller, whether consideration money was paid or not. That my vendor did not allege.
What does the instrument say?
Instrument say consideration money was paid. And my vendor also stated in the deposition, I received the
Again
consideration.
92. Again 92 is a bar. In the absence of any endorsement by the solicitor under section 58. One has to assume that it is correct.
Yes, my lord, it is correct. Now the stranger cannot challenge that deed on that ground.
So these are the
points, Miller. And my humble submission is that, Miller, so far the finding of the law and trial court is concerned, that the plaintiff should have proved the case of the defendant and defendant was in adverse possession, that finding is wrong against the law. And second is the defense, the plea of the defendant that I have perfected my right title interest through adverse possession without proving that, without following that principle, and also, Miller, refusing the status of the status of Dibakar Mishra as the true owner, contradictory plea. That is the main part.
how much time will you take to give your reply?
Lordship, I'll just have 3 points. Not a lot of something. I'll take 5 points.
Well, I was planning to keep it to tomorrow anyway.
Actually, the first question that your lordship put.
We'll take it up tomorrow. You give your reply. All right. Tomorrow you complete it. You heard his arguments?
Yes.
Have you taken note?
Yes, I have to.
Okay. Item number 2. Nothing. Yes.
The case of appearing on behalf of Mr. Kesikar.
Yes.
During last occasion, my learned senior has submitted a written note, very small written note, because the file is not with us. We are facing some little bit.
So we'll accept that and proceed.
Yes.
I think Mr. Jena, has he argued the matter?
Oh, sir, ଥିଲେ ଏବେ just ଯାଇଛନ୍ତି ବାହାର.
ଆସିବେ ତାହେଲେ ୱେଟ୍ କରନ୍ତୁ ଟିକେ 5 ଆସନ୍ତୁ ସିନିୟର ଲୋକ ବସିଥିଲେ 2-3 ମିନିଟ୍ ଆସନ୍ତୁ ୱିଲ୍ ପାସ୍ ଅନ୍ ଅର୍ଡର. Yes, take up admission matters.
Item number 26.
26 pass over.
Item number 27.
My lord, I am DK appearing on behalf of my learned senior Mr. Kesikar. My lord, respondent 3, that is Sadhu Charan Sahu, was died on 26th March 2024. So I pray some time to take substitution.
Learned counsel for the appellant submits that respondent number 3, Sadhu Charan Sahu,
my lord,
has died on
26th March 2024.
26/3/2024. The time is running. And that he would like to take steps for substitution. List this matter in the week commencing 27th August. Steps for substitution be taken in the meantime. Yes.
Obliged.
Item 28.
28 will pass off for some time.
It will be called out tomorrow? Or you want to argue today?
No, my friend Mr. Manti, Vijay Manti is that.
Tomorrow. That's all.
29.
29, an interim application I have filed for injunction. I number 189 of 2024. Maybe listed a local.
Call for the item of the Kali will take it up.
Again. 894/2024.
Item number 30. May I plead? And second appeal has been referred as reversing judgment. The present offendant is the defendant number 1.
Himanchal Patra.
Appellant number 2, 3, then 4 are also defendant number 2, 3 accordingly, and defendant number 5 is the appellant number 5 is the wife of appellant number 1. She was the defendant number 6 before the Learned Trial Court, and respondent number 1 is the plaintiff, and respondent number 2 was the defendant number 7, who was one of the purchaser. The suit suit has been filed by the defendant number respondent number 1 for declaration that the sale deeds executed by the defendant number 5, who is now dead. She was dead before the trial court while the proceeding was going. Defendant number 5 is none other than the mother of parties. The suit is for declaration that the sale deeds dependent number 5 in favor of dependent number 6 and 7 are illegal and void. So also the willnama executed in favor of the dependent number 1 is also illegal and void. And at the same time, he also prayed for equal partition of the suit property.
That sale deed was executed in favor of whom?
Sale deed executed in favor of dependent number 6 and 7.
Who are the outsiders?
No. Dependent number 6 is the appellant number 5 before your lordship. She is the daughter-in-law of dependent number 5 and wife of present appellant number 1. And dependent number 7 is the outsider. Your lordship may kindly see the movements. Your lordship I'll draw your lordship's attention to the
issues.
Schedule B.
No, let us come to the issues.
The only point on it's a reversing judgment. The Learned Trial Court found that it's a absolute property of defendant number 5.
Self-acquired.
Yes, section 14 Hindu
widow.
Yes. And according to schedule, there are 3 scheduled properties. Schedule 1 has been admitted to be joint family property, so equal share. So schedule number 2A was also 1/5 share each, and so far schedule number 2B and 3 plus 3 contains 2 sale deeds, and schedule number 2A is the willnama executed in favor of. Those have been given set at rest.
So what are they finding?
Trial court lords, you will also may kindly see page 53. Trial court judgment, running page 53.
Yes.
In the instant case, keeping in view the ratio of the decision cited above and appointments and discussion, the conclusion is irresistible that the properties purchased in the name of dependent number 4 is her self-acquired property, and she is the absolute owner of it, and she has every power to alienate the sale. Accordingly, the item number so and so, so and so. Now, what the plaintiff did, he filed an appeal, and appellate court held. Also may kindly see. Property purchased out of the fund of husband is a joint family property. That is the finding.
Yes.
Lords, page 31.
Page 31.
From the aforesaid discussion, it can be presumed that the property sold to dependent number 6 and dependent number 7 by dependent number 5 under Exhibit 5 and 7 were purchased from the fund of the husband of the dependent, for which the properties covered under item number 3 of the schedule. Those were sold under 2 different sale deeds by the Exhibit 5 and 7 can be termed as joint family property. Here, my lords, I am pausing for a moment. According to Mittakir School of Law, 115 para 115 of Mullah's Principles of Law, property purchased by the husband
or from the fund of the husband in the name of wife is the Stri Dhanam property.
She has absolute ownership.
Yes. Yes, section 14 comes to my aid. That is their Hindu Succession Act. And otherwise also.
All right, what is your substantial question?
I have reformulated, slightly modified.
Lord Sri Sanjay Kumar Pradhan, 11th Counsel for the Appellant. Peruse the impugn judgments. Considering the submissions and the grounds raised, the second appeal is admitted. You got to in the
course of hearing, the second maybe
is admitted on the following substantial question of law. Issue notice to the respondents by registered post, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter on 7th October. In the week commencing 7th October. Final decree.
Yes, I prayed for
IRA. Okay. The final decree proceeding shall continue, but the decree shall not be sealed or signed. It is the next date.
Item 31.
Against the confirming judgment. Yes, suit arising out partisanship dispute between brother and claim to the dispute between
Partisanship between
brother and sister. The brother disputed the status of the sister. The page 28 of the trial court judgment general only Oram Chandrabag is the common ancestor. And he had only one son, Navin Bag, the defendant present appellant. The plaintiffs are claimed to be the son and daughters of Saudami.
His sister.
These plaintiffs claim Saudamini is the daughter of Oram. Navin accepted throughout the case the sister, but his consistent statement is that his adopted sister. Both the plaintiff family belongs to Christian community. Hindu law is not applicable to them. As per Christian law, there is no scope of adoption like Hindu. Jehetu se palita pilla, she is not entitled for any property right. That was the defense of the High Court proceeded to consider that as a natural born daughter of Oram on the basis of school admission register only. And the school admission register original has not been produced. A certified copy produced by the headmaster, and that has been accepted, and that is only the trial court draws inference that the Saudamini is natural born daughter, and which has been confirmed by the appellate court without examining the actual natural born daughter or not.
Concurrent finding of fact, why should the court interfere?
Concurrent finding of fact basis on irrelevant evidence.
What is the
evidence? The school admission register they are giving reliance for, but the status of the person has to be considered by, as per Evidence Act, some relative, some social relationship parties has to give evidence.
The courts below are satisfied. Why should this court?
The evidence
factual issue.
Again?
Factual issue.
Not factual issue. Only such an inference can be.
Tell me one question of law. I will answer.
My point submission that drawing such an inference from the school admission register about the status of the a person is not sufficient. The status of a person has to be from the social.
Both the courts below are satisfied. They did not find any reason to disbelieve that document. So why?
They are
only because only because another view could have been taken is not a ground to admit the second.
The court below only treating that school register as a 30 years old. Only treating such document as 30 years old document by applied the principle of Section 90 of Evidence Act. That is not that is incorrect.
Yeah. Jadi apa, one thing, but one thing I can give you, if there is any chance of settlement, because this is between brother and sister.
सिस्टर तो मरी गले बर्तमान पार्टीशन हे जाइछि फाइनल डिग्री स्टेज रे भी अछि समाने ऑलरेडी सब अमीन फमीन भी डेपुट हे गले मैडम
नहीं पार्टीशन को से पाइबे नहीं
नहीं से भी पछिते से भी तापर मैडम आज्ञा
आपण की नहीं आपण की अधिका न होक चाहते
आमे प्रिंटर लोग चाहते
नहीं आपण तो अधिका तो पूरा नहीं जाई
नहीं तो बिकी भी दैछन्ते एक्स्ट्रा
मैडम गुटी पिठा दिया गेला आपण पिठार खंडे खाଇବା କଥା आपण पूरा खाइबो चाहते लागला कोन करे कंट्री लागला
एमाने एक्सेप्ट करछन तक भौणी हिसाब मु मन करनी मेडिएशन सेंटर कोटे पठे
ना ना ते फाइनल डिग्री हिसाब ना करबे
फाइनल डिग्री सरीनी
फाइनल डिग्री चलछि तो कोन ए सरजु एखा सरजु मु साथले ऑर्डर पास करते सरजु संगे सरजु this is an appeal by the defendant. You are the defendant, right? Defendant against a confirming judgment passed by learned District Judge Balangir on 30/11/2023 decree in RFN number 1 of 2022, whereby the judgment passed by learned Senior Civil Judge Balangir,
additional senior
civil judge Balangir, in CS number 95 of 2017 on 23/11/2021, followed by decree, was confirmed. The for convenience, the parties are next part. Hello. The parties are referred to as per their respective status in the before the trial court. The plaintiffs, the suit was filed by the for better appreciation of the relationship between the parties. The following genealogy is given. Genealogy court code. It is the case of the plaintiffs that they are the successors of Sodamini, the daughter of the common ancestor Aram Chandra Bagh. Further, the parties are Christians. Stop. It is claimed that the suit land was in peaceful possession of the common ancestor till his death in the year 2008. So, after his death, the suit land was jointly possessed by his daughter Sodamini and defendant number 1. Defendant number 1, Naveen Chandra Bagh. The said Sodamini died on 9/2/2012. Whereupon the plaintiffs and defendant numbers 2 succeeded to the suit land, having joint possession over half share, along with the defendant number 1, who also has half share. The suit was earlier filed being CS number 68 of 2014. Which was subsequently withdrawn. Since some area of the suit land was found to have been transferred to outsiders, allegedly in a clandestine manner, the plaintiffs, having come to know of the same, inquired into the matter and filed the suit for partition. Have they suit filed for partition? No, I think
It's a simple partition.
suit for partition. Stop. The defendant number one suit by filing written statement. It is his case that he is the only child of the common ancestor Aram Chandra Bag, and that Sodamini is just a, what do you say?
Foster daughter.
Is a foster daughter. Since the parties are Christians, the concept of adoption is not available as in case of Hindus. So, the taking advantage of the fact that Sodamini was treated as a foster daughter, her legal heirs and successors have wrongly raised a claim over the suit land. Correct me, both of you, if I am wrong anywhere on facts. I don't know.
Exactly.
Satikta, briefly, I'm a podium samay.
Main contention was apod ja kole se nahi hote. It was the only contention. Daughter
Jetiki nazar padla setting.
ସେତିକି ସେ ଯଦି ଡକ୍ଟର ତାହେଲେ ପାଇନାହାନ୍ତେ ଯେହେତୁ କୋର୍ଟ ସେ ଆଡମିସନ ରେଜିଷ୍ଟରରେ ମୋ ବାପା ନା ଲେଖା ହେଇଯାଇଛି ସେଇଟାକୁ ବେସ୍ କରିକି order
ସେଲଡିଟ ଗୁଡା କରିବେ ପୁଣି ବୋଲିକି ଡେସ୍କ୍ରିପସନ ହେଇଛି.
Basing on the rival pleadings, para, the trial court framed the following issues for determination. Para. Taking up issue numbers 3, 4, and 5, the trial court negatived the plea of the defendant number 1 that Sodamini was not the natural born daughter of Aram Chandra Bag. The further plea that defendant number 1 alone was possessing the suit land after death of his father was also negatived. On such inter alia on such findings, the suit was preliminarily decreed with allotment of equal share to the plaintiffs and defendant number 2. Where is defendant number 1?
Defendant number 1 the son. Defendant number 2 is the branch of the Sodamini.
Plaintiffs have dependent number 2 Sodamini ro puo jo.
Plaintiff defendant number half share or defendant number 1
half share.
So the allotment of half share to the plaintiff and defendant number 2 on one side and defendant number 1 on the other side. Being aggrieved, the defendant number 1 carried the matter in appeal. The first appellate court, after considering the grounds raised, did not find any reason to interfere with the factual findings of the trial court. The appeal was thus dismissed. Being further aggrieved, the defendant number 1 has preferred the instant appeal. Heard Sri E.K. Satpathy, Learned Counsel for the appellant. I have not heard you, but still I'll mention your name. And Sri Tilochan Nanda, counsel appearing for the
respondents
and
through caveat.
Who have appeared through caveat. Stop. Sri Satpathy would assail the impugned judgments on the ground by submitting that both the courts below committed manifest error in relying upon a copy of the school admission register marked Exhibit 6 to arrive at the finding that Sodamini was the natural born daughter of Aram Chandra Bag. Both the courts below further committed error in ignoring the fact that no person, no independent person, such as villager, was proved, was examined to prove that Sodamini was the natural born.
ଭିଲେଜର ଗୋଟେ ଦେଇଛି ସାକ୍ଷୀ କିନ୍ତୁ ତାଙ୍କ ଫ୍ୟାମିଲି ରିଲେଟିଭ କେହି ଭିଲେଜର ସାକ୍ଷୀ ଦେଇଛି ସେ ଇନକନସିଡରେଟ ଫ୍ୟାମିଲି ରିଲେଟିଭ ଦେବା କଥା
In ignoring the fact that no other person from the family had come forward to adduce evidence to the effect that Sodamini was the natural born daughter of Oram Chandra Bag. Stop. Having perused the impugned judgments and on consideration of the rival submissions and on consideration of the contentions raised on behalf of the appellant, this court finds that both the courts below have heavily relied upon Exhibit 6, which is a copy of the school admission register. Stop. Said the register was proved by the headmaster of the school as PW4. In the said document, the father's name of Sodamini has been mentioned as Oram Chandra Bag. The other certificate, the certificate of the secretary of the school, as endorsed in the school admission register, provide Exhibit 6 by small a, and that of the headmaster marked Exhibit 6 by B, small b, were also proved. The handwritings of the secretary and headmaster of the school who had made the endorsement was also proved to the satisfaction of the court. That apart, stop. As against the clear evidence as above, the defendant number 1 could not adduce any evidence in rebuttal. Stop. As such, both the courts below found the plea taken by defendant number 1 not acceptable. Stop. It is the settled position of law that the High Court sitting in second appeal is ordinarily slow to interfere with concurrent findings of fact unless it is demonstrated that such finding is either perverse, not or against the weight of evidence on record, or otherwise not acceptable. Stop. From directed herein before, this court finds no reason to, from what has been narrated before, this court finds that such is not the case at hand, so as to be persuaded to interfere with the impugned judgments. Stop. Resultantly, this court finds no reason to admit the second appeal, which is therefore dismissed. There shall be no order.
ଭଉଣୀ ମାନେ ଯୋଉ ବର୍ତ୍ତମାନ ଜମି ପରେ ସେଟା ଚାଲିଥିଲା 2005 ରୁ ତାପରେ ସେଇଟା ଏକ୍ସଟେନସନ ହେଇଗଲା ବନ୍ଦ ହେବା ପାଇଁ
ସେ କହିଲେ ଟିକେ ବେଶୀ ଲୋଭ ହେଇଗଲା ତାଙ୍କର, ସେ କହିଲେ ଯେ ତାକୁ ପୁରାଟା ନେଇଯିବା,
ପୁରାଟା ନେଇଯିବା, ହାତରୁ ଖସିଗଲା।
Grateful, my lord. Item 32.
Waiting for the appellant. Lordship, I am informed that after filing of the second appeal, the respondent number 2 has expired in the meantime. So therefore, I pray that Lordship permit me to take steps for substitution. It is submitted that respondent number 2 has died after filing of the appeal. So let steps for his substitution be taken within 2 weeks. Is this matter?
We commencing 2nd September.
In the week commencing 2nd September. Obliged.
Item 33. May I please, your lords? This is a confirming judgment, my lord. The second appeal arises from a common judgment and decree dated 20/12/2023, passed by the Learned District Judge Baleswar in RFA number 95 of 18 and RFA number 96 of 2018. And there were two suits.
There were two suits.
Two suits, and in the appeal, common judgment was filed. So, the plaintiff filed the suit. The present respondents were the plaintiff in the trial court below, my lord. They filed the suit for permanent injunction, my lord. Their sole contention is that there are two lots of property. One belongs to Man Govinda, another belongs to Kartik Chandra Patti. And the present the defendant, my lord, sorry, the respondent, my lord, her claim is she has purchased from both of them on different registered sale deed. That is one in both on 24/8/1993, my lord, from both of them. But they were all along possession of the present appellants, my lord. So she filed a case claiming, and the defense plea of the present appellant is that they have earlier entered up an agreement with both these persons, Man Govinda and Kartik, my lord. They have also paid some remuneration also, and an agreement was introduced, executed by them. That was also exhibited as Exhibit A and Exhibit B. My sole contention is here, my lord, in this case, and there is also the substitution constitution of law, that this has been ignored because of unregistered, my lord. Because section 90 of the Evidence Act, it is clear, very clear, my lord, that a document which is 30 years old, where here it says presumption of the document 30 years old, whereas, where any document purporting or proved to be 30 years old is produced from any custody which the court in particular case consider proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting, and in the case of documents executed or attested, that it is duly executed and attested by a person by whom it purports to be executed and attested. Explanation of the question. Documents are said to be in proper custody if they are in the place in which and under the care of the person whom they would naturally be, or no custody is improper if it is proved to have a legitimate origin, or if the circumstances of particular case are such as to render such an origin. To illustration has been given. A has been in possession of a landed property for a long time. He produced from his custody deeds relating to the land showing his titles to it. The custody is proper. A produced deeds relating to the land of which he is mortgaged. The mortgage is in possession, the custody is proper. A connection of B produced deeds relating to land in B's possession, which are deposited by him, B, or on a self-custody, the custody is proper. So my response submission is, my lord.
But can it take away the rigors of section 17 of the Registration Act?
If my sole contention is that, my lord, if without going maybe that will be in the further.
What is that document?
That document is a agreement between them that I have paid 2,000 in one case, 2,000 rupees, another 5,000 rupees, and that has also been.
So being more than 100, rupees,
Mhm.
it is registrable provided it purports to convey any title.
Yes, Your Lord.
Provided.
And
it
that was
seeks-
also in possession. My response submission is that those were agreed that.
No, the provision which you read just now of the evidence
Yes.
relating to
Section 90 of the evidence.
Section 90 relating to 30 years.
30 years.
Whether that can overcome the defect under Section 17 of the Registration Act.
If I think.
When the document referred to, I'm posing this question to you, you may seek to answer. The document or the instrument or the deed, whatever is referred to in Section 90 is obviously a valid deed.
It is a valid deed. I have not.
Referred to a valid deed.
But prior to that, why my responsibility is, if there is a document which can be produced, yes, the person who has sold it, he must be aware of that
Maybe
document.
for collateral purposes, maybe you may use that document, but straight away to hold that validity of the document on the basis of Section 90.
You may see in specific purpose act, one has promised to pay me that the mere agreement is there. Now by getting more money, he wants to sell it to somebody. So there is stood for specific purpose is different. That is one aspect. My I only have a case on Section 90, my lord, because this has been ignored. My responsibility is that ought not to be have been ignored, because a document which is 30 years old and it has been witnessed by somebody, another the same person is selling to that person. That stands the scrutiny of law, my lord. That ought not to be ignored in limine.
Difficult case, Mr. Kamtor. Difficult case.
I admit. But by overcoming both the cases, it is. I mean,
how has the court below dealt with it?
They simply.
What is the document? Was it marked as an exhibit?
Exhibit A and Exhibit B.
How? Let us see how. Exhibit A and Exhibit B.
Exhibit A one is a signature of Mulakat Panda. Exhibit B one is exhibit a signature of Kartik Chandrapati. ସବୁ ଅଛି ଦଶକତ ଫସକତ ସବୁ ଅଛି ସେଟାକୁ ଆଉ ମାନେ ସେକ୍ସନ 90 ଟାକୁ ସେ ଆଦୌ ଏଠି ଇଏ କରିନାହାନ୍ତି ରିଫ୍ଲେକ୍ଟ କରିନାହାନ୍ତି କି ଯାଇ ବି ନାହାନ୍ତି ଏଇଠି ଲେଖିଛନ୍ତି ପେଜ 16 ଟା ଟିକେ ଦେଖିବା
Page 16 of the trial court.
ଏଇ ଯୋଉ ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ
Okay.
ରନିଂ ପେଜ ଦେଖନ୍ତୁ 42 ଦେଖିଲେ 42 ରନିଂ ପେଜ ଲାଷ୍ଟ
42, yes.
ଲାଷ୍ଟ ଇଏଟା ଦେଖନ୍ତୁ ପଢି ଦଉଛି
Yes.
Upon scrutiny of above, last paragraph.
Yes.
Upon scrutiny of above oral and documentary evidence, this court found that agreement by Exhibit A and B have been written in a plain paper and they have not been scribed on stamp paper as per the Indian Stamp Act. Furthermore, scribe of Exhibit A and B have not been signed by Exhibit A and B, except Exhibit A and B is no agreement for purpose of purchasing the suit. No, that has been ignored, totally ignored. Section 90 टाକୁ से आनी ही नांती. Whether that can be, तापर discuss भी करी नांती. Why when it is 87 रे जब
Is it in the first appeal? Was this one of your grounds in the first appeal? So they disbelieved Exhibit A and B. Election variety?
Disbelief ignores a cow.
Being unregistered documents having no effect at any point of time.
Ignore करचंती हो. एटी भी अच्छा एटी भी लेक्चर.
So that is why I asked you.
रनिंग पे 20 टा देखो तो appeal रे. Appeal रे भी से कोई नहीं गुटे कथा.
सेटा पढुछु बा.
Appellant though claimed possession of the running by 20.
Yes, I'm reading.
Appellant though claimed possession of the suit land by virtue of Exhibit A and B. Such plea could not be submitted by adducing cogent, clinching and reliable. The section 90 टाको पूरा पूरी आके बुझी दी चंदी.
No, see, so you want us to look at the surrounding circumstances. If those agreements were available, why were they not enforced? It could have been enforced by filing, as you yourself said, by filing a suit for specific performance. That was never done.
Suit for specific performance have not done. But तार evidence value टा कौन पूरा
माने evidence value पे हेले सेटा registered होइथवा दरकार. Stamp Act is section 31
मु केसटा करी नै ना
কেস করছি সিএ ফার্স্ট
করু but you are relying on exhibit A and B
ডিফেন্স প্লিতে ମୁଁ দেখাইলি যে দেখନ୍ତୁ ଆଜ୍ଞା it is I am having these documents unregistered document but this is agreement ମୁଁ ଯଦି କେସ୍ ଫାଇଲ କରିଥାନ୍ତି I will go for suit for specific performance
no ସେ କଥା କୁହାଯାଉନି exhibit A and B
ଆଜ୍ଞା
those agreements they have never been enforced they are remaining as it is as a plain paper
custody ରେ ଅଛି ପୁରା একটা କହିଲେ it is a proper possession in custody এটা କଣ ଇଗ୍ନୋର କେମିତି କରିଦେବେ
extremely difficult however section 90 will not come to your aid
ଲାଙ୍ଗୁଏଜ ଟା ତ ମୁଁ ସପୋର୍ଟ କରୁଛି ଆପଣ ଯାହା
yeah I am willing to grant you one more opportunity ଆପଣ if you find out କାଲି କି ଦେଖନ୍ତୁ
କାଲି
ତ ଲିଷ୍ଟ weekly list ଅଛି କଣ ହଉ weekly list ଅଛି till Friday ଅଛି you can find out decisions if you want I have posted it from the very beginning whether section 90 of the Evidence Act
अच्छा 19 रा पढ़वा देगी
वो प्रश्न आगे पढ़ो मत सुन दो whether it can override section 17 of the Registration Act and as per section 17 it's a compulsorily registrable document
तो हियरिंग रे होगा क्या इस नोटिस टा के न कर देला के जाली से भी
ए अपन मते आगे मु कन्विंस हेले तापर एडमिट कर नॉल करबी नहीं
कहीं के ना सेक्शन 30 डेफिनेटली रजिस्टर्ड डॉक्यूमेंट ऊपर ଅଛି सेक्शन 19 टा so definitely it is having a on standing section 90 is there जब बाबू यदि माने you produce an old document of 30 years old or more then it has evidentiary value एटा को इग्नोर कर परिबे नहीं तो जेतेबेले एटा ऑलरेडी अछि आ किनिछि बोल कर खोज एग्रीमेंट टा खोज ताको पूरा इलिमिनी रे ये कर दबाटा not registered
no see that is the crux of the issue that it has not been registered it has been lying in your custody for years together and as you say it has completed more than 30 years very difficult anyway I give you one more opportunity upon Friday bhitere any day you are prepared you can make a mention we can take it up
1 week after so I am to room it
is there in the weekly list
चेष्टा करी काली तो चेष्टा करवा दे
कोन बोले बस एटू टका देखियो है ना यस ଆଉ କଣ ଅଛି ଆଉ ଏଟା କେତେ ଗଲା ଆଇଟମ 33 ଗଲା ଆଚ୍ଛା 34 ଓକେ ଅଛି ଥାଉ ଛୋଟ ଥାଉ ରିମେନିଂ ମ୍ୟାଟର୍ସ ଟୁମୋର 37 ଯାଏ ଅଛି ନାଇଁ ତ ଦି ଦିନ